As we resume after tea, I recognize the member for St. Augustine. You have an additional 9 minutes, 20 seconds to complete. And would you like to avail yourself of the 15 one time? If you so yes. Desire, you have
Thank you so much,
you have my wish.
Thank you very much. Maybe I'm being optimistic to suggest I will take in the other 15 minutes, but one never knows. I'm grateful to you. Mr. Speaker, I was making the point that the real crunch issue in this entire proceeding will be the amendment now to read lawful possession. And I had been given the example where I had been personally affected by the issue of persons who trespass illegally, but we had to go through the process of the courts to vindicate the right to take back possession. Now, for the sake of completeness, my former neighbor had produced a court order dealing with some matter in relation to herself and the bank, and produced that as some form of stay in the minds of herself, and the police either deliberately or mistakenly held on to that as authority to say it was a civil issue. And for the record also, I want to say, because I saw my little friends on the back bench rose in anger in some form or fashion to making, for my exercising not just my right, but my duty to do the right thing. This property was put on the open market for sale by the bank, having had the order of the court. I need to, because some are misunderstanding. There was no abuse in any form or fashion, and I make no apologies except to say I'm very sorry that our neighbor had that issue. And we paid a lot for that premises, of course. So, and all monies have been accounted for. Let's be quite clear on that. But that takes me to the point I really rose to speak to in this debate. Many years ago, when the property tax had come, I shouldn't say it's 10 years now, 2009, it was read into the budget, the property tax. And we had led, together with the member for Chaguanas West and others, the Access Tax program throughout the length and breadth of this nation. It was about protecting people's homes. There was a fear, a legitimate one, that the taxes that could have been imposed then would have been so onerous that persons, especially the elderly, may not have been able to pay, and then the subject of the house or the home could have ended up in the ownership of the state. The subtext of that, of Axe the Tax, was leave my home alone. Mr. Speaker, there is an infection going through this nation that is worse than any flu. It is worse than a lot of diseases. It is this. There are many of our citizens who did all the things that a classic society requires, having gone to school, educated themselves, trained themselves, worked diligently in industry or in wherever they worked, and through no fault of their own, and a classic example has been the Petrotrain closing, and many others who have lost their jobs from ArcelorMittal and a host of other places, who have mortgages that they took in good faith to own homes, and now, through no fault of their own, having lost their income, many have at the point of losing their homes, just like my neighbor.
Two have lost.
Right? And those who have not reached that point are living in mortal fear of losing their homes. Now, home ownership in a nation is crucial for what we call the center of the society to hold. The moment you start interfering with the right to own a home and the fear of losing it, and for those who unfortunately may have lost it, it is a horrifying experience. Children who would have been born into a house, know nothing else as their home, and for whatever reason, the banks exercise their right to mortgage, and they're put out lawfully, and very often you hear that these homes may be sold for far less than their true value. And I implore the Attorney General and the government of the day, let us really look at that. and create a fund or some mechanism. America did it under the Great Depression. During the Great Depression, Fannie Mae was created so that TTMF, as an example, I just give that example, can take up the loans or mortgages from commercial banks because they have a business to run, and they cannot just write off things. And for those who truly have no alternative and who cannot pay their loans, their mortgage, for the state to bear that for a time period until things can get better. Because if it is that we leave things as they are going, then not only will families be destroyed in the process, we've heard our Senator Indarsingh speak of the, what shall I say, the anxiety problems, the mental health issues that attend the stress is relevant to what we're dealing with. I'll tell you how. Because just like a person can come with a gun or a knife and take the home and throw you out, equally under the gun or knife of the law, it could happen, like it happened to my neighbor. Due process, yes, and the point being that the process can crush those who have no choice. And therefore, there is no comparison in terms of the method of doing it, but the effect can be the same. And therefore, I'm calling upon this government, please.
Mr. Deputy Speaker, Standing Order 48.1, please. We are not debating the repossession of homes by banks. We are debating a criminal bill, but criminal activity. We are not debating who can't pay a mortgage. Please, Mr. Deputy Speaker.
And I'm making, sorry.
And, okay, member, again, tighten.
Yeah.
Right, tighten quickly and move on to your next point, please.
We're dealing at the end of the day with dispossession of property. Persons who are occupying property to be dispossessed by forcible
Mr.
entry.
Deputy Speaker, Standing Order 48.1. We are speaking about dispossession by criminal activity, not by banks, not by people not being able to pay their mortgage via due process. This is a criminal piece of legislation about dispossession by criminal activity.
And again, member,
Yeah, thank you.
I do not want to overrule, clearly, but I would like you to tie in the point and, tie it in with regards to the criminal intent and move on, please.
I am most grateful. My learned friend from St. Joseph doesn't wish to hear about the plight of those who can lose their homes. In other words, right? Not surprising, and we shall have to take other action outside of the parliament, possibly, to create a movement to get this, to protect the homes. So back to where we are all on the foundation of homes and the protection of it. And my friends do not see the relevance of that. Not surprising either. This issue of the law.
Member for Naparima, right? Based on how the day has been progressing, I'm abiding by Standing Order 53, right, as we continue in. Proceed.
I will direct then my contribution to the learned Attorney General, who understand these things. In terms of adverse possession, Attorney General, you'll have a problem in terms of the owner of the premises, who is the, as you put it, lawful owner, the adverse possessor, and these are things I need some clarity on it. They haven't not got, for instance, a declaration from the court or anything like that. Who then exercises the right? Because there could be a right in the adverse possessor against the owner, but the owner has a legal right. And therefore, would the lawful owner with title, deed, be able to go to the police and then say, this person is a trespasser? I mean, and you're talking about 14, 16 years may have passed. These are things that we need to look at because you could create mayhem. And in particular, in the squatting communities, and my friend from Oropuchi kind of glanced at it. But in the squatting communities, that is where there will be a lot of violence, member for Laventille West, where persons who are bigger and stronger can say, look, this is mine. And we have real-life examples of that. I know. But in the implementation of it, when you speak to lawful ownership, which is the amendment, lawful possession, in the interim? Can the police get involved in those matters, right? So that's why when I opened, I said, we really do need to pay, we want to help. We want this thing to work. We do know it's a real problem and we require serious consideration. Legislative change, yes, but practical implementation for it to work. I do not wish for you to pass as slow as it is, and then you end up creating unforeseen consequences.
Specifically, what is the difficulty?
The difficulty now would be in terms, yeah, sorry. Yes, the difficulty you will have is by the interpretation of the lawful possession. There's uncertainty as to what that could mean. Right? You have occupier already, but now you reinterpret it as those who are in lawful possession. So, Mr. Speaker, I really do hope that we could work this thing through and come up with a more than just cosmetic approach to it. The Attorney General has recognized the contribution for Oropouche East when he spoke about the need for witness protection and all of those things. And yes, effort has been made legislatively to protect those things. But unless we have a robust return to respect for law and order, the protection of property rights, then an understanding by the police service and those who are there to enforce our laws, then the best of laws will not be properly implemented. So I look forward to the next contributor and to see if we could really work this thing out today. And I am most grateful for the opportunity to have contributed to this debate. Thank you very, very much.
I recognize the member for San Fernando East.
Thank you, Mr. Deputy Speaker, and I thank you for the opportunity to contribute to this, an act to amend the Trespass Act, Chapter 1107. And Mr. Deputy Speaker, before I begin, let me commend the member for Laventil West for piloting this bill, Mr. Deputy Speaker, as well as taking the process to where we are today. Mr. Deputy Speaker, the member for St. Augustine made a few points, but he was otherwise largely irrelevant. Madam Speaker, I can't address the matters the member rose with respect to his neighbor because we only have his side and we don't have his neighbor's side of the story.
The court side.
Madam, Mr. Deputy Speaker, this is not about taxes, Madam Speaker. This bill is about the protection of a constitutional right to the enjoyment of property.
That's right, that's right. That's what
That is what the government is seeking to protect. And the member is right, home ownership is crucial to a democratic society, and that is the reason why we are amending this bill today, Mr. Deputy Speaker. And to address very quickly the member's point about lawful possession. Mr. Deputy Speaker, lawful possession is possession that is lawful. And
Members, one second. Please, mobile devices are either to be switched off or on silent. All right? Members, proceed.
Thank you very much, Mr. Deputy Speaker. Lawful possession as compared to actual possession that an adverse occupier or possessor may have. Actual possession. And in any event, lawful possession is a matter that can be dealt with the courts of Trinidad and Tobago. Mr. Deputy Speaker, let me just put some background into this, as I always like to do. This bill deals with trespass. And Mr. Deputy Speaker, trespass is usually a tort that is actionable at common law. And it involves the unjustifiable interference with land in the immediate and exclusive possession of another. And trespass to land, Mr. Deputy Speaker, is not criminal unless there is a specific statute that creates criminal offenses and criminalizes certain action. And that is what we're here to deal with, Mr. Deputy Speaker, the Trespass Act 1852. And this Trespass Act, Mr. Deputy Speaker, criminalizes 3 offenses. In Section 3, being found without reasonable excuse. in any enclosed yard, garden, ground, cultivated lands, in and about works of any plantation, oil field, refinery, and oil tank farm. Section 4, Mr. Deputy Speaker, being on lands where a notice is placed without reasonable cause or excuse for being there. And Section 5, fastening any boat or vessel to a wharf or marina, Mr. Deputy Speaker, where a notice is placed without reasonable cause or excuse. The amendments that we propose today, Mr. Deputy Speaker, are relevant. The Act itself, despite being over 160 years old, is relevant today. And the amendments that we propose is, one, to update the language to create more modern language, to increase existing penalties, therefore offering a greater deterrent to the acts of trespass, and as well, Mr. Deputy Speaker, to create new offenses criminalizing new types of trespass where lawful residents or occupiers are being displaced. So, Mr. Deputy Speaker, let me just get to the meat of the matter. And it is with respect to the new offenses being proposed in Clause 8. Proposes a new 5A and 5B that deals with forcible entry and forcible detainer. And Mr. Deputy Speaker, before I get there, let me explain one of the problems that motivated the solution that we are proposing here today. And that problem took place while I was housing minister. Housing minister for 2 years. Madam Speaker, late in 2017, the HDC started receiving complaints about persons being displaced and dispossessed of the lawful occupation of their apartments by the criminal element in Clifton Towers, by threat, intimidation. Another complaint was that vacant apartments were being broken into and occupied by the criminal element. And this was not a new problem, Mr. Deputy Speaker. This problem occurred, as the member for Oropouche admitted, since 2011. And the member for Laventille West read out an article where the member for Oropouche, as he then was the housing minister, gave a comment with a lot of bravado. But the HDC, under the member for Oropouche East, did absolutely nothing. Absolutely nothing. In fact, Mr. Deputy Speaker, I was the housing minister. Mr. Deputy Speaker, Mr. Deputy Speaker,
Well said.
the member for Oropouche East responded in two ways. One, he admitted today. The other way was arbitrarily, when they received these complaints, they would simply just shuffle people around, take them out of Clifton Towers and put them somewhere else. All over the country. They would play that shuffling game. Or, Mr. Deputy Speaker, they would increase the security by giving contracts to their friends and family. And let me give an example. It was simply too costly for the HDC to maintain the cost, the running cost of these facilities. It was unsustainable, Mr. Deputy Speaker. It was unsustainable. This government, in the situation we found ourselves in, we could not kick the can down the road. We had to deal with it frontally. And I gave the instruction at the time that we will engage the police, we would engage the police in joint, with the joint army patrols, and we would evict these unlawful occupiers. But I could admit to you here, Mr. Deputy Speaker, that response failed. It failed because when these unlawful occupiers were evicted and they were arrested, the only charge that was available to the police was the same charge that the member for Oropouche East raised under the Summary Offences Act, which is an act that deals with rogues and vagabonds sleeping in. And the penalty for sleeping in, Mr. Deputy Speaker, is a fine of $200. $200. Mr. Deputy Speaker, I speculated at the time because when these unlawful occupiers, the criminal element, were evicted, arrested, I don't even know if they were charged. I suspect that the police may have found that the time and effort it would take to process these persons who were charged was simply too much for the paltry $200 that they would be fined with. So they were arrested in the morning, and in a few hours, they would return to Clifton Towers to continue terrorizing and breaking into the very same apartments that we took them out of. So, Mr. Deputy Speaker, there was no deterrent, and there was little or no protection offered. And Mr. Deputy Speaker, when you compare the consequences, or the consequence rather, of someone who is a displaced residential occupier with the paltry sum that these persons are charged with, this government and the member for Laventille West, the one pushing this matter to the point where we are today, we simply had no choice but to protect the people of Trinidad and Tobago. So, Mr. Deputy Speaker, two new offenses of forcible entry, offenses that were not previously found in our jurisdiction of Trinidad and Tobago, but as the member for Laventille West would have alluded to, are found in other jurisdictions. So, forcible entry. The new 5A criminalizes where a person uses force, threats, intimidation to enter land or a dwelling house, which is in the lawful possession of another, in order to expel that person and take possession of the land, and does so otherwise in pursuance of an order of court or lawful authority. And from the proposed section, Mr. Deputy Speaker, from the proposed section, it is clear that force, threats, or intimidation to enter land or a dwelling house can be used against a person, and that act is criminalized. But, Mr. Deputy Speaker, when you take the word force, I respectfully submit that the force can also be used against the property. That is, break open the locks, break open the windows, and enter into the property and take possession of the land so as to expel the person in lawful possession of that land or dwelling house. Mr. Deputy Speaker. So, it is immaterial whether the force is used against the person or the property. And there are examples, Mr. Deputy Speaker, why I'm saying that this interpretation has to apply, because in other housing developments, criminal activity, we have found, may have chased persons in lawful possession of apartments to reside elsewhere temporarily. Or a person may actually go abroad for a period of time, and in these housing estates, they pay their rent on time every month. So they are in lawful possession. Yes. And the criminal element in those properties, and this is a phenomenon that the HEC has to deal with, the criminal element breaks into those properties and takes possession of the properties and continues to live there. For free? For free. Displace the owner. For free. In fact, Some of those persons, and the member for Point Fortin will tell you, some of those persons actually come to the HDC and ask you to regularize them because the person who was in lawful possession, they're nowhere to be found. They left the premises. So that, Mr. Deputy Speaker, will also be caught by this act. Mr. Deputy Speaker, there is one, for the member for Laventille West and for the Honorable Attorney General, there is one amendment that I would like to be considered. And I apologize for raising it now. It was only in refreshing my memory with respect to the Clifton Tower situation that it came to mind. Yes. This matter was already laid in Parliament. In the Clifton Towers experience, the criminal element had also taken exclusive possession and expelled workers of the HDC from the office that was on the compound at Clifton Towers. Additionally, the criminal element had also taken possession of the washroom facilities to the exclusion of all the residents at Clifton Towers. And the amendment I would ask to be considered is whether we can include premises instead of land or dwelling house, because premises captures all. Or perhaps it can be addressed later down when we do the regulations. So, Mr. Deputy Speaker, moving on to 5B, forcible detainer. Forcible detainer applies to any person who unlawfully, in or upon any land or dwelling house, maintains or attempts to maintain his possession or occupation thereof, and does so by force. And the force here, Mr. Deputy Speaker, would apply in cases where, for example, they enter into the premises and they change the locks. That can be interpreted as force. Or in the case of land, where they barricade the land using a fence and they place a gate and they place locks. That is the force. Or even, as the member for Laventille West, they put 2 pit bulls in the yard. That can also be force. Mr. Deputy Speaker. And in both instances, we have placed a penalty of $100,000 and imprisonment to 15 years. Forcible entry and forcible detainer. And Mr. Deputy Speaker, that reflects the seriousness of the crime and the breaches of persons in lawful possession of land or dwelling houses, the breaches to the Constitution of their constitutional right to the enjoyment of their property. So, with this, Mr. Deputy Speaker, it's not a revenue raising matter, as the member for Orapooch East suggested. It is to provide a very serious deterrent to these types of activities and these types of actions by the criminal element in society.
Serious remedy for serious right.
Correct. Serious. And I would also propose that the same amendment, for consideration, that the same amendment be looked at 5B, forcible detainer. Mr. Deputy Speaker, with respect to Clause 5, where an amendment to Section 3 is proposed, we have deleted 9 time because we've accepted that our present day circumstances and with respect to the scourge of crime, we need to outlaw the trespass that occurs in enclosed yards, gardens, etc. We need to outlaw those things at any time during the day. Or night, Mr. Deputy Speaker. And with respect to the penalties, we have increased the penalties from a mere imprisonment for 3 months to a fine of $50,000 and to imprisonment for 10 years. With respect to Clause 6, we propose a Section 4 amendment where Section 4 deals with trespass on any lands where there is a sign posted, and the Honorable Attorney General dealt with the matter of the sign posted. It is prevalent in modern-day legislation attaching to these types of criminal trespass, so I will not go there. And we have increased the fine to $50,000 and to imprisonment for 10 years. And we have increased it from a fine of $200. And Mr. Deputy Speaker, it is my hope that this new Section 4 as proposed could and will offer landowners some sort of protection. Some sort of protection, added comfort from the scourge of squatting that goes on in this country on private lands, where persons enter onto lands, put up their properties, enclose their properties, and dispossess landowners from the right to the enjoyment of their properties. So, Mr. Deputy Speaker, the fine of $50,000 and to imprisonment for 10 years, Mr. Deputy Speaker, that also seeks to deter this type of activity where persons in society, and some of them know the law better than the landowners, where they come onto lands with the intention of adversely possessing and taking possession of lands. So, with respect to Clause 7, Section 5, this deals with marinas. And the increased penalties, we ought to also deter this type of activity. And we have a lot of marinas on the west coast of Trinidad, southwest coast, and this should deal with any sort of illegal activity, smuggling, where our borders are found to be porous. So, Mr. Deputy Speaker, dealing with let me just touch on the home invasion point that the member for Oropouche East made. The member for Oropouche, he harped on this home invasion point, and I think his misinterpretation of the whole situation came from the member for Siparia, Senior Counsel, Prime Minister, as she then was. But this matter does not, the new Section 5 and new Section B does not deal with home invasion. Home invasion is more akin to burglary, Mr. Deputy Speaker. Forcible entry and forcible detainer are two very different things from the matter of home invasion. Home invasion deals with where you enter premises with the intention to create an indictable offense. Enter into a home with the intention to create, to commit an indictable offense. And it's totally different from what we are dealing with here. So, Mr. Deputy Speaker, in conclusion, I want to continue to commend the member for Laventille West, for the Honorable Prime Minister, and for those on this side for seeking to protect those who are in most need of protection, for seeking to protect those who are most in need of shelter and most vulnerable in society. And I commend those on the other side to support this bill in its entirety. And with those few words, Mr. Deputy Speaker, I thank you.
I recognize the member for Mayaro.
Thank you very much, Mr. Speaker. Mr. Speaker, thank you very much for acknowledging me as I enter this debate. to debate an act to amend the Trespass Act, Chapter 1107. Mr. Speaker, let me first congratulate my colleagues from Oropouche East and St. Augustine for a very thoughtful, well-articulated delivery this evening in this House. Mr. Speaker, I want to agree with my colleague from Oropouche East when he suggested that this bill should have been repealed in its entirety and a new piece of legislation come before this House this evening. The Act, sorry, thank you. The Act should have been repealed and a new Act being placed before this House because thank you. There is so much of colonial and archaic thought processes in this. I think we would have been better served with something new coming here before this House. Mr. Speaker, one of the things that I would like to explore in my short contribution today is why the police has failed or why have they been hesitant to act using the old trespassing law? Because I'm of the view that the law has been in existence since 1837. It was amended in 1937, somewhere I think as well. 36, sorry. But yet the police clearly fails to act when these reports are made. And I decided to reach out to a few police officers, to some retired senior officers as well, to get a feeling from them as to why more charges have been laid when these issues come before the police. So I will explore a bit of that as my contribution proceeds. Mr. Speaker, I think this bill is a very important bill. I think it is absolutely important for basically two reasons. One, this bill in a functioning form, a well-oiled and well-greased form, will allow the protection of homeowners. And two, it will allow the HDC in that respective area to have more homes available for legal applicants. Because I do know, and I know I would have conversed with the former Minister of Housing on many occasions for assistance in getting homes cleared that had been vandalized, had been broken into by criminal elements. And they were depriving citizens who would have had legitimate applications from these homes. So I really think the bill is very, very important, providing it is landed in a good format to go forward. Mr. Speaker, the Honourable Member for Laventille West, when the Honourable Member first read this bill, he reminded us of the Constitution, Section 4A, concerning the right to individual life, liberty, security, etc. The enshrined rights of property owners, Mr. Speaker, are just not here for the protection of homeowners from violent gangs and thugs, with the specific reference that we've been focusing a bit on the HDC housing developments and so on. But it is really to protect all citizens and even to protect citizens from the state. And I'm not saying that this government will use this act to do anything untoward, but it's really, we have to make sure that no government, now or in the future, can use law to oppress people in any format. So I want to touch a bit on that. Mr. Deputy Speaker, I have a concern with Clause 4 of the bill. And I know several speakers, they spoke about this issue around lawful possession of any premises. And if you would allow me a couple of minutes just to stick to that point. I don't know if the government have thought about this in any particular way, or perhaps they have thought about it, but there are people who have a legitimate expectation, who have been on land for close to 16 years, who may have a legitimate expectation of adverse possession, and they are there 14, 15 years, not necessarily 16, when the law gives them some right to it. But this law comes into effect, this trespassing law, and then they can be treated as criminals after 15 years of possession, but they don't have lawful possession. So, Mr. Deputy Speaker, at that point in time, the state may have the ability to toss people out because of that at the end of the day, based on this piece of legislation. So I'm wondering if that may be an oversight, or if that is a purposeful move to deal with matters like that. Mr. Deputy Speaker, there are countless people in this country who could suddenly lose whatever little rights they may have if this bill was passed as it is, with that insertion of this lawful possession. Mr. Deputy Speaker, we have seen most recently where in road construction, in highway construction and so on, there has been a bit of pulling and tugging with citizens concerning their land and their property and so on. And I am wary that there may be instances where the trespassing law as it is being formed here can be used to really move people out in a way that it deprives them of a legitimate expectation if they were to make their 16 years on the property. Mr. Speaker, another area of the bill that, in reviewing it, that I had some concerns with, and I raised this as a matter, so in the winding up, Minister could, address it to clear it up in my mind, is at clause 5 and clause 6 of the bill, as it pertains to the amendment of section 3 and 4, where they are increasing existing penalties. I have an example, Mr. Speaker, where, in accordance to section 3 of the Act, let's suppose one of my constituents in Mayaro have a garden that they tend to, but in order to access where he's planting, he needs to pass through someone else's land, which is very likely in a lot of cases where you have farming happening. Under this particular amendment, he is now legally guilty of trespassing and could be opened to a fine of $50,000. Right? I'm just asking, perhaps you could clear it up. All right? Take, for example, Mr. Speaker, you may have hunters as well. And again, these are things when I were discussing it with a few folks within my office and a few of the constituents, they raised some of these matters. The Attorney General or the Minister could, clear it up for me. But you have hunters who sometimes accidentally cross into people's land. They may set up their tents and so on. And they too can be guilty of trespassing. And, the fine of $50,000 if there is a complaint and a charge and so on. But, Mr. Speaker, I mentioned those two areas to contrast it with a case of someone who is trespassing into your property, and they do it so with a bit of threatening words, violence, possession of a cutlass, of firearms, but yet the law or the charge, or he'll be liable to the same fine of $50,000 as well. So I'm thinking, Mr. Deputy Speaker, that the proportionality in all three cases, I think that the case where you have people using threatening language, violence, which the forceful part, that the fines could be a lot higher to deter that sort of behavior. Because you want the punishment to fit the crime at the end of the day too, Mr. Deputy Speaker. So, because there is a difference between a man going to work in his garden and someone trying to get into your property and injure and harm somebody. So the law seems, as it stands, it doesn't make that difference to make a distinction between those two persons at the end of the day. So I'm hoping some attention can be paid to that. And I know the query about whether the penalties were designed to be a revenue generation opportunity. But I would hope that having stiffer penalties and higher penalties, it's really designed for behavior changes. Because I want to agree with a lot of speakers, we live in a society where, I mean, people take the law into their own hands. We are, claim to be a lawless society, So I'm hoping these higher fines really work towards behavioral changes, Mr. Deputy Speaker. Mr. Deputy Speaker, I just want to raise the matter of Clause 8, wherein the bill it proposes to amend the Act by inserting after Section 5 two new sections, 5A and 5B. While I don't have a problem with those two insertions into the section, Mr. Deputy Speaker, I want to agree with the member for San Fernando East by making an adjustment by changing the word dwelling house and perhaps using the word premises as well. I want to agree with that because if you can amend dwelling house to reflect either a room or apartment, it can give that section a little wider meaning in terms of the law. Or perhaps you can change dwelling house. It could be removed and replaced with premises for this particular area. So it gives it the widest possible meaning in terms of the law, Mr. Deputy Speaker. Mr. Deputy Speaker, and the reason why I make that suggestion as well is because under the Liquor License Act, Chapter 8410, it sees premises as every room and place under the same roof or within the same curtilage occupied with or belonging to any house, premises, room, or a place. So at such term, premises in Section 12 of the Act should be amended to include that definition, if possible, Mr. Deputy Speaker. Mr. Deputy Speaker, and I just want to turn to the issue that I referred to. Why is the police not acting? Why have they not acted using the law as it is? And I know when the Honourable Minister, member for Laventille West, spoke, he did make reference to this matter of the police and the army having to go into AGC developments sometime in 2018 and had cause to break doors and locks and so on to remove people. The Honourable Minister suggested that while that may have been so, he was unsure whether people got charged or not. And that speaks to the point that I'm making. Why, after that effort, no charges have been laid? Mr. Deputy Speaker, I have a particular case in Rio Claro where a young lady was...
Thank you very warmly for giving way. My friend, the member for San Fernando East, as he spoke a moment ago, explained that the only criminal charge that the police had available to them in those circumstances was under the Summary Courts Act, some rogues and... Summary Offences Act, sleeping in. And that carried a sentence of $200. And having paid it in the morning, they're back in the afternoon. No real deterrent. He explained that. Thank you very much.
Sure. Thank you, Honourable Member. And I want to take what the member has said and just expand it a bit. In that, by using this example from this constituent of mine, she was granted, I think, an apartment in one of the complexes in Couva in 2016. She was the victim of 2 break-ins, and at one point in time, in fear of her life, she stayed for a little while by a relative in Arima for about a month or 2. When she returned, the house was occupied by someone. Tried to get in, made reports to the police, and up to today in 2019, there has been no action in Hoover, yes. I had cause to both send copies of her letter, her request, both to the Minister of Housing, to AGC, and I forwarded a copy to the Commissioner of Police as well. And today the police has taken no action. She has been advised to take civil litigation against the people who have occupied her home. And as far as she is concerned, she has all her documentation, her lease agreements, her pay, and although she has been out of the apartment for about 2 years, she's paying her monthly installment because she believes that at some point in time, she's going to get her home back. So, and I have no doubt that this would help, but I want to bring a point where I feel would hamper her from getting help, and I'll get to that, Mr. Speaker. When the honourable member laid this bill, when he had the first reading, the honourable member made a very important statement, and if you allow me just to read it. He said, there are many instances of these incidents across Trinidad and Tobago, Madam Speaker. The police often, when invited to take note and get involved, see these as civil matters and have expressed feelings of powerlessness to treat with these matters in the way good sense and justice demands. And the minister brought up a very important point with that the police feels powerless. The minister is saying that this amendment will fix that problem. Having spoken to several police officers, I am of the view, and I stand corrected, perhaps the minister in Wynab will correct me on that the stumbling block for the police seems to be in Section 9 of the Act. And if you allow me just to read what Section 9 said, it has been amended. There's 2 amendments to it, but the Act itself reads like this. Nothing contained in this Act shall authorize any magistrate or justice, which is a justice of the peace, I believe, to determine any case of trespass in which any question arises as to the right of title to any lands or any interest therein or occurring therefrom. So I'm asking, and maybe the AG or the minister may seek to comment as to why there is no amendment to deal with the issue of the powers of the magistrate in Section 9 itself. Because the police is saying, why, when they go to deal with this matter, and the person says, well, I have rights to it. The police is saying, well, look, we either have to find another way to get around that, either under the summary offenses, loitering, larceny, something, rather than using the Trespassing Act. Because the minute it goes before the magistrate and there's a claim of rights, then the magistrate kicks it down to the civil court. Police officers say, well, sometimes you go and you get involved at the point in time and there is aggression, and sometimes you may have to forcefully arrest someone, and then you open the police to wrongful arrest and so on. So they have always been very hesitant to take action using the old law as it stands because of the issue of the magistrate and the magistrate's power, Mr. Speaker. Because it was a widely held view from the police officers that I spoke to that in most, if not all of these cases, all the defendant has to do is as soon as he lawyers up, the lawyer gets a piece of paper showing that he has some sort of title, a deed of gift from a grandfather, a great-grandfather, something that is 50 or 60 years old, and the claim of right, because of the claim of right, the case goes into limbo. So that is one of the reasons why a lot of the time the police fails to take action, and they tell you, look, go take legal action, put them in court. And yet, the person who is the rightful owner, they are left to decide how I'm going to proceed with a civil matter. Mr. Speaker, the issue, I believe, in Section 9, if it is not dealt with the issue with the magistrate, it will continue to make this amendment very weak, because the police here is the engine to carry out the work that is required for the benefit that the state is looking for. And if we don't get the police to use it, well, then we have a problem. Mr. Speaker, I have a question as to perhaps why the magistrate who is sitting in the summary court, he, by virtue of the law, is not allowed to deal with a matter of title or rights when it comes before him. But if the same magistrate is sitting in the civil court as a judge, he has the competency to deal with it. So one piece of the law saying, no, he can't deal with it for whatever reason. I don't know, there may be a legitimate reason for it. But I'm looking at the magistrate as a person. In another court, he has the competency to deal with it. Why don't we allow the magistrate, by virtue of legislation, to have the power to deal with the matter right there? So it is not kicked to the High Court or to a civil court. Because when these matters have to go to a civil court, Mr. Deputy Speaker, you would know that lawyer fees, legal fees, from the time you mention High Court, it just goes out of proportion. And a lot of people cannot afford to hire attorneys to get these matters before a civil court. And it remained in abeyance for years. So, Mr. Speaker, I have no issue with the inclusion of 5A and 5B to make summary offenses which the magistrate can hear in the lower court. Because the police that I spoke to was of the view that if there are issues of rights and title, that part may be kicked to the civil court, but issues where you have criminal behavior in terms of force, use of force, and so on, the magistrate in the summary court will be able to deal with that matter there. But again, we come back to the point of you have unscrupulous attorneys outside there who can fabricate a document for you in the morning. By the time the police charges the man on Friday, by the time he gets to court on Monday morning, the attorney turns up with a document saying, well, he has some sort of legal right to the property. And we're not speaking specifically in terms of HDC homes, but in any premises, any piece of land or so on. So it really becomes the bugbear for the police in executing their duty, Mr. Deputy Speaker. Mr. Deputy Speaker, there are a couple comments that I have with issues with the amendments to Clause 9 that, with your permission, I would like to just briefly take a look at. The issue concerning magistrates, why it is the magistrate cannot hear those cases. And you have, under some new laws that this Parliament has passed, magistrates are now sitting as judges in several matters. And I think the competency issue of the magistrate may have been something 60, 70, 80 years ago, but today they may be well poised and competent to deal with matters of title and rights and land and so on. So I'm hoping that perhaps regulation that we are allowing the minister to have that power to do could perhaps give magistrates that power to deal with matters of title and rights in the lower court. Again, litigation will be a lot cheaper because of higher attorney fees and so on. And then if you have a number of these matters, having to go to High Court is just going to be adding to the burden that's already there in the High Court. Mr. Deputy Speaker, I am also suggesting that perhaps via regulation, if it's possible, that the magistrate's power can be expanded to include the granting of injunctive relief in certain cases as well, Mr. Deputy Speaker. As such, it's my humble view that the above suggestions, I feel, would make the administration of justice convenient and advantageous to the litigants at the end of the day. Because we should not be passing legislation here, and there is a lot of gray areas where the police will not have the power and the authority to act. And when it reaches before the magistrate, he too is compelled and forced to toss it somewhere else. So we will end up back to square one again. So, Mr. Deputy Speaker, with those few comments that I have made, I've done it with the best of intentions, based on my understanding. I want to see good law. This is good law to pass if it's done correctly. I think it's going to bring relief to the citizens. I think it is important for our constituents to have this trespass, this amendment bill, be done right to really give the police the power to act on their behalf. So, Mr. Deputy Speaker, I trust that the AG will take some of these suggestions and go forward in strengthening the bill and bring relief to the thousands of citizens who face these challenges on a daily basis. For these few words, I want to thank you, Mr. Deputy Speaker.
Member for
Thank you.
I recognize the member for Toko.
Thank you, Mr. Deputy Speaker.
Toko Sandy Grandisari.
I feel I am compelled to stand this afternoon to take part in this debate and act to amend the Trespass Act, Chapter 1107. Mr. Deputy Speaker, a lot have been said this afternoon about police and where they belong, about police and being rogue elements, about police and policing, about persons asking for police advice. But this afternoon, Mr. Deputy Speaker, being a past police officer and a proud one of that, a person who puts country first, a person who has given 34 years of my life to serve Trinidad and Tobago, and I continue to serve Trinidad and Tobago in a higher level, I feel proud to stand here this afternoon representing the constituents of Toko Sandigram and to speak about this particular bill. Mr. Deputy Speaker, trespassing is a legal term for the situation in which one person enters into the land of another without permission and the legal right to be there. Depending on the circumstances and the law in place, when the act occurs, trespassing may be considered a crime, a civil wrong called a tort. If the trespass is with an illegal intent, this is a crime. But in Trinidad and Tobago, Mr. Deputy Speaker, trespass had tended to be treated as a civil matter. And the act has not been amended since 1936. However, the upsurge in the new antisocial and criminal behavior in our society, which concerns persons preying specifically on vulnerable senior citizens, and I dare say, in my time in the police service, especially during 2013, when we had a lot of uprising by gang members, and people spoke only about houses, but I can speak to places like Karapo, where we had a notorious gang leader, where they had senior citizens living in those areas where they were given land, and they were threatened to move out. And if they did not move out, they were burnt out. So they burned them out in order to create a whole community of people engaging in gang activities. So this afternoon I sat here and I listened to many of the contributions of those on the other side. And they tend to take this discussion to a different level, when I think the intent of this legislation was really to address what was happening in 2013. And Mr. Deputy Speaker, these things happened in 2013. I was a police officer then. And I was wondering, what is the government of the day doing to help us? What is the government of the day doing to bring good legislation to make my job easier in that time? Because at that time, I was the then senior superintendent of the Northern Division, where we had a lot of gang activities taking place. But lo and behold, this afternoon, I have to belong to a good government, a government which sees importance in bringing good legislation to make the job easier for the police officers to engage in. So I feel compelled, Mr. Naparima, I feel compelled to stand here this afternoon to thank my colleague Laventil West and my dear Attorney General, Fernando West, for bringing good legislation which I know could be used even up to today. Mr. Deputy Speaker, we speak again about police not taking action. There are two situations. You have criminal law and civil law. When a person comes to a station and bring a report that leave him, let me talk. I could deal with that. When a person comes to a station and brings a report, which is a civic matter, a civil matter, a police officer doesn't have the authority to engage in that particular matter. the advice will be given to the person to go to the court and bring up the person. When these things happen, Mr. Deputy Speaker, what do you think happens after that? They are burned down. Argument takes place. A poor, unsuspecting old elderly person comes to the station and make a report. Okay? They are sent to the court to make a report and get a lawyer. Mr. Deputy Speaker, these are the gaps in the system. And these are the gaps which this piece of legislation seeks to correct. And I'm to sit here this afternoon and listen to all sorts of explanation about police officers not doing their jobs, being rogue elements. This government understands. This government understands the job that we have to do. And this government is ensuring that we bring the legislation in place to get the job done. Not sit here and condemn officers. We sit here and we condemn officers and we call them rogue officers. Bring our personal matter, St. Augustine. Bring in a personal matter. A personal matter. And the poor, unsuspecting police officers responding and seeing a lady in despair, having lost her husband, and now having lost her home. Taking action. Taking action. And
Member, 1 second. 1 second. Please, not across the chamber. Right? Please, not across the chamber. On both sides. Go ahead, member.
Thank you, Mr. Deputy Speaker. I sat here in dismay, listening to the explanations, listening to the story given, just to end up saying that police officers are rogue officers. When the law has a gap, the law has a gap. And if you all can't understand that because you want to go to a different level and bring it to a different spin, I feel very sorry for you all on that side. And I can tell you, I sit on this side, and I have all the blood of a police officer. And I have all the information of every one of you sitting on that side. And I can understand why you all do not support good legislation, because just 3 years ago, you all were saying the same things.
Information on me, I feel threatened. But I have no information. I'm an honest citizen. I'm 70 years old and I'm proud not having information.
Members.
I will stand.
Members, overruled.
Yes, I have said enough on that. I've said enough on that.
Member for Couva South. I think member for Couva South. Member for Laventille West. Member for Couva South. Again, you have been constantly making your comments, but I think now is the time that I need to make a comment with regards to the constant repetition of making various comments at every particular thing that goes on. So please, member for Couva South. And again, other members, I'm not tolerating the shouting across the chamber, please. Proceed.
Thank you, Deputy Speaker. So that I also want to speak about the increase in the fines with respect to this piece of legislation, and to let us all know that prior to this law coming into play, Mr. Deputy Speaker, I seek your assistance.
She's going us east. She's going us west. Right? She's going us west. Proceed.
Yes, Mr. Deputy Speaker. So that we see, we now have a fine of $100,000 and imprisonment for 15 years. That in itself should act as a deterrent to persons who are thinking of engaging in this particular act. And I want to remind us that, yes, these acts have been happening in Port of Spain, in Sami Grande, Couva, San Fernando, Carapo, Siparia, and to name all these areas around Trinidad and Tobago. But The government that preceded this government didn't see it fit to bring this legislation in place.
That's right, that's right.
I saw the member of Miaro. He was really between and betwixt. He was saying yes and he was saying no. You know, he said yes, it's a good legislation, but then he was bringing some points about some police telling him certain things. So I don't know what is his stand, but the things he said yes to, I think he was on point because he understood that there is a need for this particular legislation. And I want to compliment him for seeing that. At least he saw part of the picture. Mr. Deputy Speaker, I want to remind you, and I want to bring to the House that, you know, this government is concerned about increasing and improving the quality of life for all our citizens. When a citizen feels that they are protected by a government, their quality of life is improved. The fear of crime reduces. And Mr. Deputy Speaker, this act is one that is going to create that opportunity for many of our citizenry, young and old, rich and poor, and our elderly. And with these few words, Mr. Deputy Speaker, I thank you.
Recognize Caroni Central.
Thank you. Thank you very much, Mr. Deputy Speaker. Mr. Speaker, I don't think I want to respond to many things said by the member for Toko, Sangre Grande. All I would ask her, though, is that if she has any file on me, if she could simply tear that page out and get it. But that is the limit of what I would say about that. You might have to throw out the book, I guess. But, Mr. Deputy Speaker, in all seriousness, I want to reinforce, I think, what most colleagues have said on our side, which is that we recognize the good intention behind the bill. And we understand what was the thinking that went into it. But most of us feel that by addressing that problem in the way that it has been addressed, more problems have been created. And because of that, we are cautious and we are making suggestions that we think will improve and enhance the bill and give us a better bill on this issue of trespassing. So it is not that we are against the bill or the intention of the bill. It is that we feel that the bill is quite limited. And that is the real issue. Because we have no problem with property rights and recognizing it as something that must not be violated. We agree with that. That's an important principle. But one of the points that the member for Oropouche East made was that he located the bill in 1852. And he mentioned some of the things in the bill, Mr. Deputy Speaker, which really showed that it really was a bill rooted in colonial times. And if you wanted to modify it and modernize it, as in fact the member for Laventille West indicated that he wanted to do, you couldn't just tinker with it to address what was essentially an urban problem that has now begun to spread, and which was an HDC problem that is national. So it's not limited to HDC, it's not limited to urban settings. It is a national problem. And it involves more than just house. And it involves more than just land. And when you talk about house and land in Trinidad and Tobago, it is bound to be controversial because this is the basis on which people build their lives in countries such as ours. I just want to show the significance of this, the fact that this bill was in 1852, just for a minute. Emancipation, Mr. Deputy Speaker, was in 1838. So if this bill was 1852, this act, I mean, if this act was 1852, the original act, think of that in relation to 1838. Indenture started in 1845. This act is 1852. Indenture finished in 1917. The last amendment on this one was in 1936. So you're talking about a context here where you're bound to have problems if you're trying to bring the law into 2019. And this is the real issue. And we don't have a problem with the intention of the bill. We have a problem with how the transition to the current time has been managed. At that time, you had the state. The state was the owner of a lot of land in the country. But at that time also, you would have had big parcels of private ownership. Okay, they were plantations, basically. It was a plantation economy. You had a planter class. You had state ownership, you had private ownership. The state ownership was then known as crown lands. That is what it was known as. You know, look at the transition, look at the years. And agriculture was the big product. People were planting cocoa and, you know, that was the nature of the society. What we have had since then, and I'm fast-tracking now to the contemporary period, is that squatting is an issue in Trinidad and Tobago. State housing is a phenomenon of national life. Private development is organized business in Trinidad and Tobago. Real estate development is a major business, and you have international players in it in Trinidad and Tobago. The spread of property ownership is quite significant in this country over that period and in the contemporary time. And properties change hands all the time. And you have, as I mentioned before, the growing phenomenon of squatting. In our time, private ownership is under assault, though. And you have home invasions, which has been mentioned here by several of my colleagues who spoke so well, the member for Mayaro, the member for St. Augustine, and the member for Oropouche East. So private ownership is under so much assault that several years ago, the concept of gated communities became a reality and has now evolved as the preferred form of development in the country. Squatting has grown on both state and private lands. Some squatter communities have become sustainable communities. I have one in my own constituency which has evolved into something like that. Some have become problem areas. They have become, some of them, breeding grounds for crime itself. State housing has evolved since the 1950s, early 60s. And we have a situation where you have state housing which has turned out to be excellent, as in the Diego Martin area, the Diamond Vale area, one of the first ones that was ever done in this country, where you have serious organized residential communities. But you have other state housing that is a problem. They have, not only are they a problem, they were created under conditions in which problems that were bound to happen. So in that kind of situation, as we deal with the bill, we have to be cognizant of these kinds of issues. Now, most private developments have generally done well, although there have been problems with some, because sometimes the developers themselves do not follow town and country planning regulations to the letter. They don't follow what the local government tells them, etc. But by and large, the majority of them are pretty well done with reasonable standards. The gated communities, as I said, have become a way to go. there has been runaway expropriation of state lands in the country. You know, people just walk into a place. You were mentioning it just now, member for Toko Sangre Grande. The fact that you had people just walking on lands and taking them over, sometimes with violence. And the state has not been able to cope with the claims being made by people for legalization of ownership of lands in which the state is the owner, and they are or have been entrenched on the lands for some time. So there are many land tenure and land regularization issues, and this has been a particular nightmare in the agricultural sector, Madam Speaker. And my constituency has a lot of people involved in agriculture in it. Pridal larceny is a persistent problem. This is a violation of let me use my own pronunciation. So so this is a problem, and this, of course, is a violation of property. Home invasion, land invasion, and the growth of violence have become a factor almost everywhere. So, as you have private home ownership, private land ownership, the rental market, all of these things growing, lease market, all of these growing, but threats to legitimate ownership and legitimate claims to ownership have also grown. That is to say, people seeking to have legitimacy bestowed by the state, but threats also to this, both on private and people occupying state lands. That has also become an issue. Now, the limitation I feel with this bill in the presentation of the minister, both when he introduced the bill for the first reading and now that he spoke to the bill here in this session, is that he speaks of the general problem, touching on some of the things that are mentioned in here, but he particularizes the issue as an HDC problem. And I don't know if it is right to have a bill that simply addresses that problem when we have all of these attendant and related problems in the country that also need addressing. And I say that in good faith. The issue may have pertinence to the HDC, but the issue of trespass is a much bigger problem. It is a problem of property rights and of human security, on the one hand. So the problem is property rights and human security on the one hand. But on the other hand, Madam Speaker, and you would remember I started by saying that it was a colonial bill in colonial times, 1850s. And what we had there, and therefore the whole issue of property ownership and how it has evolved, it also raises the problem of social inequities in the society and the need for social justice to provide property ownership opportunities for and access to this for all who would want or desire it. So these are the twin sides of that inherited problem, Madam Speaker, from the history that we have had and the way the society has evolved. On the one hand, you want to root the capitalist elements of your society in property ownership. In fact, capitalism rests on that. Land, labor, capital, home ownership is fundamental to the capitalist idea. But at the same time, you want to address the question of justice in a society that has really been formed by colonial and imperial extensions. And the end result of that is you've had an evolution of a society that has been rooted in a number of inequities in the society. So the attendant issue now is the growth of violence and the forceful overpowering of others and predatory behavior towards the weak, the vulnerable, and the unsuspecting. And the minister was good enough, member for Laventille West, to raise that particular issue. And some members on the other side did raise it as well. And our members on this side acknowledge that as a critical issue. So the bill seeks to make amendments to the Trespass Act, but it's really about three things, and I want to reinforce this. Property rights and property ownership rights and human and property protection and security. Social and economic justice and the need to provide legitimate and legal routes to land and home ownership in the society. But thirdly, it wants to introduce laws or elements of the law, that's to say clauses in the law, which make enforcement of laws to deal with violence against the person and against property in the context of predatory behavior possible. And these are the three pins, so to speak, on which the law hangs. And we have no problem with the three of those, except that how it has evolved. And the limitations of the bill because of the few clauses in it and the small amendments, really two major, well, a few amendments. Now, this issue of land and property and the home invasion, and I don't want you to think that I'm being sensational here, Madam Speaker. I just want to mention a couple of things. We had a situation some weeks ago in which a 64-year-old farmer, her name is Angela Mackenzie. She's a landowner. She had a nice piece of land. I don't know how much it was. It might be 10, 12 acres or something like that. She's a gardener. She's a farmer. Somebody passed up and down the place. I don't know. They had some altercation. And the next thing you know, this woman who lives by herself simply eliminated from the face of the earth. All right? And what recourse does this lady have? You know, you had a situation where some years ago, and this is not in your time, so you need not be defensive about it, John Cropper, who was my good friend, Angela and John were good friends of mine. And John Cropper, somebody walked in his house and eliminated, you know, in his own property, in his own household. You had a situation where a doubles vendor in Balmain, Vancouver, 2 o'clock in the morning, Nashad Radhe, eliminated in his house. In October of 2018, Kenneth Ordins, 67 years old, invasion in the home, murder. And finally, and this is the last one, Nizam Mohammed, 60 years old, again, home invasion and murder. I mean, it is relevant to what I am saying because I'm saying that the law is limited. You cannot come and tell me that what you are doing here is protecting a tenant in an HDC home in Duncan Street, and that you are bringing a law to do that, and you are not doing it for all of these people and all of these things. You can't tell me that that is good law. And that is the whole point of my argument, Madam Speaker. And I think the minister understands that. He may understand what he's trying to do. And I think he understands that he's trying to do something that is worthwhile, which I concede. But I think he also understands that, look, maybe something is amiss here and we could make it better. And this is what I'm appealing to. That is the point of Parliament. So my point, therefore, is that the bill addresses an immediate problem, but it does not go far enough, and it creates loopholes, I think. And secondly, it does not address the issue of how sustainable enforcement will be achieved. Madam Speaker, this is a very important thing. My colleague from Oropouche East said, you know, you pass the law and you have the big fines, but how do you get this? And I think this is an important consideration if we're going to pass a law on something like this, which we are acknowledging, all right, the government is acknowledging that it is a real issue. They are saying it emerged in 2013. The member for Oropouche East said it emerged in 2013. But this is the law that has come now to address it. So how do you make the enforcement sustainable? How do you make sure that it does not turn out to be a nightmare, which is what it is promising to be? And of course, the bill does not address the issue of social and economic justice that I mentioned, which is the other side of the equation. So let us take a look at the text of the bill. All right? Now, it changes in clause 4, I believe, from, it changes from possession of any land and substituting the words lawful possession of any premises. Okay? I want to deal with this issue of lawful possession of any premises. Again, it talks about in the same clause the issue of enclosed yard. I want to deal with that particular issue. It talks about the issue of occupier. All of these are in clause 4. I also want to address some issues that arise in clause 8, and I might comment on the penalties. Now, many of the issues in clause 8, from my point of view, I am going to raise some questions, the minister can answer them. And I raise it on behalf of farmers and people in the agricultural sector. What is the significance of value of deeds of comfort for them? Does that give them lawful possession of their land? Because the word lawful is now inserted in the bill. And I do not know, I need that clarified for me here today because I'm talking on behalf of thousands of farmers in my constituency. And the last thing by DEFCO was that they had about 13,000 farmers in this country, and many of them unregistered. So, do deeds of comfort constitute lawful possession? The second thing is, what happens to me if I am a farmer and I am in the process of application for regularization of a lease? And it is not yet consummated. That's right. Am I a legal owner of the land? Do you know that there are farmers on state lands, Mr. Member for Laventille West, and because they are not in possession, so to speak, they cannot fence their land? It is against the law. Well, you have to give me that.
If they are farming, please. If they are farming, they are in possession.
Yeah, you've been cute with me.
That's the law.
Huh?
That's the law. If they are farming the land, they are in possession.
But are they in lawful possession of any premises? Because, you see, this goes on to say you could fence your land and you could build this and so on. You can't fence your land. Do you know that there are farmers who have been waiting as long as 30 years for a lease? Do you know that new farmers on state lands are regarded as squatters on the land? No, this is important, man. Don't tell me 48-1.
Madam Speaker, I rise on 48-1. It might be important, but
but
relevant. I seek your ruling, Madam Speaker, as to whether the submissions of my friend from Caroni Central important as they might be, are they relevant in the context of this debate? That is
Yes,
what I
they
see.
are.
Yes, they are.
Well, we-
And I rule in accordance with the point he's developing now as what constitutes lawful possession that is relevant. Please continue.
Thank you very much, Madam Speaker. So the issue here is what rights do they have pending lawful conveyance of the land in the form of a lease? Now, you yourself said, Minister, that the police would not intervene because it is a civil matter, and you're now making it law so that it becomes a criminal matter. But ask yourself the question, if you had the problem before of it being a civil matter, whether police will now intervene on farmlands without lawful ownership, if the law is now that you have lawful ownership. A farmer, even if he has been on his land for 30 years, waiting on the authorities to look at his file, need permission to construct a fence or a building, even if it is wood, not temporary. So the question here, and this is the fundamental one, does this bill at all address any of the issues faced by farmers, or is it ignoring them completely? The other issue in the agricultural sector is the issue of registered farmers and non-registered farmers. Of the 13,000 farmers, a large number of them are not registered. So, now the other issue. This clause talks about an enclosed yard. I said I would raise this. Is surrounded by a fence or a natural boundary or a combination of fence and natural boundary. B, is enclosed in a manner that indicates the occupier's intention to keep persons off the occupier's premises or to keep animals on the occupier's premises. Now, a gated community, Madam Speaker, has a fence around the contour, the perimeter of the property. All right? Trespass, therefore, involves any violation of that gate or the fence of the whole property. I want to ask how this particular bill addresses this issue of gated communities and the trespass issue in relation to a gated community. And I don't have to tell you about gated communities, they're all over the country now. Now, then the issue of property and firearms possession when criminals have more guns than law-abiding citizens. And any criminal can buy a gun on the street for a few $100s or rent one for less. And the reason I raise that is this. If you are talking about an issue in the country, now, you presented part of this bill as a kind of crime prevention bill, and you are preventing this as a crime prevention bill in which you don't want criminals to take advantage of ordinary people for no reason whatsoever, to violate them, to take away their property, to run them out, etc. If you have a situation like that, which is emerging in the country where you need the legal basis to deal with it, you now come to make an amendment to do that. Does that raise the serious question of how people protect their property rights in the country and how they are treated in the law, in the disbursements of firearms, and all of those issues to protect their property? Yes.
Say, I would rise on 48.1 in respect to this point.
Okay.
Okay,
I will
so I'll
leave
ask you
that,
to move.
Madam Speaker.
Yes.
No. other issue, since you're dealing with violation of property, is the violation to the places of worship. How would this work in relation to that? In my own constituency, within recent times, we've had 3 such events at the Lakshmi Narayan Temple, at the Hare Krishna Temple, at the Faith Assembly International Temple, and in the country itself, we've had violation at Trinity Cathedral. In Sangre Grande, on the Toko Manzalina Road, we had the breaking in of a mosque and the interfering with the prayer room and taking of money and so on. Does this bill address that? Does this bill address the issue of the protection of property rights and the criminalizing of that in relation to this?
You mean sacrilege?
Now, the issue, Madam Speaker, also of squatter regularization, land tenure issues, land ownership and property ownership, I mentioned. The other issue that I mentioned, the social justice side. Now, there are 450,000 households in this country, according to the 2011 census, or thereabouts. But there is an HDC waiting list of 140,000. How to solve this problem? And this is the issue, the balance of property rights of the 450 and the route to opportunity of the 140,000, or I don't know how many, who live below the poverty line and own no
Honourable
property.
Member for Caroni Central, the original 30 minutes are now spent. You have 15 more minutes to complete your contribution if you wish.
I'll take a few minutes. Thank you. Thank you, Madam Speaker. Now, in terms of the justice issue, I will not raise everything in relation. I raise just one point. For instance, I raised the agricultural issue. There are about 1,000 jobless graduates in agriculture at the tertiary level. And we have an agricultural production and food import problem in the country.
So, Member for Caroni Central, while I understood your earlier context setting, remember we're dealing with a particular bill.
Yes,
so unless what you're saying, you could tie that back to this bill. The other things I understood you to be tying it back to what is lawful possession.
Yes.
I'm not sure now with employment where we're going.
No.
All right, so I remind you, I'm standing on 48.1 and asking you, unless you can very quickly tie that to this bill, I'll ask you to move on.
Would you give me an opportunity to explain it in just 30 seconds? And it was that, for instance, a route to land possession could be created for agricultural graduates in a way that would make them legal owners of property. That is the point.
Next point. Thank you very much.
Yes. I will ask just one more question before I close. There is a section in 9, clause 9(2), which reads, it is clause 9(a)(2). Regulations made under this section may provide that the contravention of any regulation constitutes an offense and may prescribe penalties for any offense not exceeding a fine of $25,000 and imprisonment of 5 years. Now, the reason I raise it is because I don't know what the regulations would say. I mean, the minister would get up one morning and make a regulation. I have no doubt that it would be related to some reality in the society. But immediately that regulation is made without coming to Parliament or anything. That matter becomes an issue that I have to deal with as a citizen. So the uncertainty of it and the arbitrariness that it seems to suggest all right, notwithstanding that you expect a minister to be responsible and look after his office properly, is an issue that I want to raise. The question is very simple. Why would you want to make a regulation like this? So I find it kind of odd, Madam Speaker, and I simply want to ask the question. So, Madam Speaker, in summary and in closing, what I would say is that we recognize on this side, I certainly do, the good intentions of the bill. We also understand the legitimacy of the issue having to do with the violation of ownership of HDC properties, homes, apartments in the urban sector, and the fact that something has to be done to take care of that. But I want to raise the wider issue if we are going to pass a law to deal with what is essentially the violent trespassing on property and sometimes assault on the person. If we are going to deal with the whole business of trespass on land and homes and property, and if we're going to deal with this properly on behalf of the law-abiding citizen, and if we are going to deal with it, anchoring it on the principle that property and the ownership of property should involve inviolable rights. If we are going to take that position, then this bill is too limited, Madam Speaker. And what we need is a bill that comprehensively take into account home and land ownership in a much more meaningful way as it exists today in 2019 in Trinidad and Tobago. Thank you very much.
Member for St. Anne's North, Port of Spain.
Thank you very much, Madam Speaker. Madam Speaker, I'm pleased to join and enter this debate and hopefully not take up too much time, because I think the points have been made, they've been beaten, and certainly from the other side we're hearing a lot of tedious repetition. The first thing I'd like to say, it is quite misleading to suggest that this bill was brought here to address all of the issues by the member for Caroni Central. For the member for Caroni Central to get into a discussion and try to say home invasion and lead to the heinous murders of law-abiding citizens over the years, and that this particular bill should address those situations, is completely a complete attempt to mislead the public. You don't charge a person who's entered a home and murdered someone with trespass. So that suggestion is completely ridiculous. You charge them with murder. To hear what my friend from Orapooch East said earlier, that why are you bringing this legislation? Because this legislation, you know, everyone knows the sentence for murder when you're found guilty on murder is death by hanging, and it doesn't play a deterrent role. So what are you worrying to bring any piece of legislation to deal with issues such as home invasion? Completely ridiculous as well. Our purpose, and the public is quite aware of it, Madam Speaker, as legislators, are to bring law to the Parliament's floor, to debate it, and to put in place the tools. This is a tool. And I've also sat here and asked permission to enter this debate because I find it quite distasteful to suggest and to reduce this piece of legislation in the most derogatory terms and manners I've heard from those on the other side today, by suggesting it's for HDC, and it's for persons who live in HDC houses, and to talk about Duncan Street, and to talk about East Port of Spain in the most derogatory of manners. So as a member for Port of Spain North, St. Anne's West, and a representative for a large part of East Port of Spain, I rise for the people that I represent and point them out for being the racists that they are here today,
for being those who have come here to attack those who sit in HTC houses. I am not withdrawing it. You all have sit down. Sit down.
No.
On what point of order? Right?
Order.
Right?
Order.
And you have money launderer. Right?
Okay. Honorable Member for Port of Spain North, St. Anne's West, I'd ask you to withdraw that statement that you just made. Member for Naparima, there's a statement that you made that I would ask you to withdraw. Oropuch East, there's a statement you've made that I ask you to withdraw. Couva South, 2 wrongs do not make a right. Okay? And from here forward, tolerance needs to be a guiding principle. We started.
I withdraw I am speaking. I withdraw the reference to the term racist.
I withdraw the reference to anything having to do with drugs.
Speaker, I withdraw whatever I said about it, and I'm withdrawing from this chamber as well.
That's good. Please continue, Member for Port of Spain North.
So, Madam Speaker, again, I'd like to put on the record as a representative for Port of Spain North, St. Anne's West, where there are a number of HDC housing projects that fall within my constituency, that I take great offense to the derogatory manner that Oropuch East and others have referred to persons who reside in East Port of Spain South, Lavantel, Maloney, and all of the other HDC housing. But let the population take note today that on the 8th of February 2019, those on the other side have come to Parliament and attacked persons who reside in these HDC housing projects in the most derogatory of manners.
Madam Speaker, 48-4. We have not attacked people living in houses, in houses in his constituency.
Madam Speaker, 48-6.
Member for Couva South, I have not yet recognized you. And, all right, Member for Couva, for Naparima has just raised an issue, and let me rule on that. Member for Port of Spain North, St. Anne's West, could you find another way to say what you wish to say? Just 1 minute. Member for Couva South, you also have a point of order to raise?
Well, Madam Speaker, you have ruled so.
Member for, just 1 minute. Member for Couva South, you've demonstrated time and time before how well familiar you are with the standing orders, and therefore, and also have in here articulated about respect. I expect that you will do things in a proper way. So I've addressed you, I will sit, and then you can answer me.
Thank you, Madam Speaker. You have addressed the issue based on what my colleague from Naparima has written.
Member for Port of Spain North, St. Anne's West, if you could just find another way to say what you wish to say, please. That would be parliamentary.
Thank you very much, Madam Speaker. Madam Speaker,
An intervention?
Yes.
It's an interruption. You're asking him to give way?
I'm not giving way. The 47-1 isn't giving way.
On a point of order, Madam Speaker.
Okay.
And the point of order is that by suggesting.
So 1 minute. So it's either you have to be on 1A, yes, right? You're on 47-1A or 1B?
1A.
Okay, so you're rising on a point of order.
Yes, I'm rising on a point of order,
and which is
misleading the House by indicating, Madam Speaker, that anyone or several members on this side spoke in a derogatory manner about East Port of Spain and the housing.
Okay.
All we did was...
So member for Carney Central, I think it's the same point that member for Naparima raised, and the member for Port of Spain North, St. Anne's West, is about to address that. Okay?
Thank you very much, Madam Speaker. Madam Speaker, the Hansard will reflect in the clearest possible terms the contributions that were made by those on the other side prior to me rising to contribute to this debate. Those who were looking, those who are listening, including all of us on this side, heard what they had to say. They suggested, Madam Speaker, that this bill, the suggestion was that this bill was being brought to deal with HDC tenants and persons living in HEC, and the repeated use of Duncan Street, etc. So, Madam Speaker, moving on from that point, this bill was brought to answer specific ills that are facing our society now. This bill was brought to widen the scope of trespass in Trinidad and Tobago, and in particular, Clause 8, that was referred to quite expansively by my friends on the other side, treats with something known as home invasion. And I think those before me, in particular the mover of the bill, have said enough about what home invasion is, what it entails, and the truth is that in our constituencies, it is a reality. It is and I even recall now what Oropouche East was saying in the most derogatory of terms about one of those crime hotspots, the crime hotspots of East Port of Spain, and this bill is being brought to deal with the crime hotspots of East Port of Spain. This is not something that is confined to any HDC development. This is not something that is confined, as far as I am aware as the Minister of National Security, to any specific area in the north of Trinidad. It happens throughout the whole of Trinidad. I heard my friend from Maruga Tableland talking about it, my friend for Toko Sangrandy talking about it. I know for a fact it happens in Central, it happens in Enterprise, it does happen in San Fernando, it happens across the country, Madam Speaker. So to come here today and suggest to the public that this bill is too limited and is being done for specific areas of Trinidad and Tobago is completely false. What I'd like to add is my friend for Caroni Central took a lot of time talking about farmers and how farmers can't fence their lands, etc., and getting into a whole discussion about possession of agricultural lands. That is a completely different concept. And I've suggested to the mover of the bill a simple amendment to Clause 8, where they say a person who uses force, threats, or intimidation to enter land or dwelling house, you just add the word or premises, because premises is defined as including A, any lands, D, any garden, ground, cultivated lands, plantation, oil field, refinery, or oil tank and farm. That simple amendment immediately addresses all that Caroni Central was saying, and saying that this is not good law, it's not expansive enough. Simple solution. Add the word premises in that section, Clause 8, and the new sections 5A and 5B. It completely captures all of that. But this is about trespass. This is about invasion. A lot of conversation was had about, well, what does this do to address the issues of crime in Trinidad and Tobago? And one of the things that was talked about, again quite disingenuously, was, does this address places of worship? Madam Speaker, I have stood here, I believe in the other place, and answered questions at a particular period of time, week after week, as to how the Trinidad and Tobago Police Service is addressing the issues of criminal attacks on places of worship. They've increased their patrols, they're focusing on it particularly, they're intervening with all places of worship. And in fact, knock on wood, and I hope it stays that way, there has been a remarkable decrease in it since the Trinidad and Tobago Police Service has focused on it. A Trespass Act is not to deal with crimes on places of worship. As my learned friend for Laventille West was quite rightly suggesting, there are specific offenses, criminal offenses, dealing with any crimes committed at places of worship. Sacrilege, also when you enter places of worship, there are specific acts that deal with the protection of places of worship. So again, I have to put that on the record, lest people believe that the government is not doing anything to protect places of worship. The point is, Madam Speaker, this bill is not meant to be something that captures all criminal activity in Trinidad and Tobago, and that's how they were trying to sell it on the other side. That there's this crime going on, and there's that crime going on, and this bill doesn't deal with persons who enter a home and murder people. This bill doesn't deal with people who enter and commit acts of predial larceny, people who can't pay mortgages, etc. Madam Speaker, I think it is as a sign of embarrassment that when this began to arise, nothing was done. Even though the leader, the Honourable Member for Siparia, and the then line minister for HDC and other issues did nothing. And now this government has bravely taken a decision to give the Trinidad and Tobago Police Service yet another asset, another tool in their arsenal to deal with specific incidents of crime. I also heard it mentioned by the member for Urupuch East that nothing was we passed anti-gang legislation and nothing had become of it. Again, I tell the population of Trinidad and Tobago, that is completely false. There have been a number of charges under the anti-gang legislation, specific offenses created. I congratulate the Trinidad and Tobago Police Service and in particular, the OCIU for the remarkable and tremendous work that they're doing in tackling gangs. We are not going to be failed like the state of emergency, where you lock up a whole set of people, you have to release them. Hundreds of cases in court right now as a result, and we're still paying out millions of dollars in damages. Proper work is being done. I have said in the past few months, operations now are being intelligence-driven. The Trinidad and Tobago Police Service is working with the intelligence agencies, and that includes in the area of anti-gang legislation. Charges have been laid, specific charges created by the anti-gang legislation, including harboring gang members, including persons who are trying to intimidate people from reporting gang activity. Charges have been laid. Those are before the court. And I give the population here, Madam Speaker, through you, the assurance here today on the 8th of February 2019 that there are more charges that will soon come. And I congratulate the Trinidad and Tobago Police Service for their new way of policing. So, Madam Speaker, I just wanted to intervene, and I thank you for the opportunity to do so, to say that it is a complete fallacy and once again an attempt to mislead the population of Trinidad to say that this bill is not good legislation and it is not addressing a very serious set of criminal activity taking place throughout Trinidad and Tobago. Not only on Duncan Street, not only in East Port of Spain, but throughout Trinidad and Tobago. And I thank the Minister and the Ministry of the Attorney General for taking the lead and the charge on this, along with the technocrats and the draftspeople from the Attorney General's office. And I stand there proud to be part of an administration that has finally tackled something we all knew was going on. And we can say we did it because we weren't. I'll leave that part out because Urupuch East isn't here to defend himself. And I don't want to speak Spanish. So, Madam Speaker, with those few words, I thank you for the opportunity to contribute.
Member for Couva South.
Thank you, Madam Speaker. As I join this debate on an act to amend the Trespass Act, Chapter 1107. Madam Speaker, when legislation is brought to the Parliament of Trinidad and Tobago, the members of this opposition has always demonstrated a sense of responsibility to country and a sense of responsibility to all citizens of Trinidad and Tobago, executing our responsibilities inside this Parliament and also engaging the stakeholders and national community outside of this parliament, Madam Speaker. And I have listened attentively to all the speakers during this debate. And it was rather sad that a bill that is designed to address something that is affecting the law-abiding citizens of this country, that the member for Port of Spain North, St. Anne's West, and the Minister of National Security, who is committed to upholding law and order and so on in this society, will allow the debate to degenerate to what are on the basis of ethnic lines and so on in Trinidad and Tobago. Madam Speaker, I want to remind the member for Lavendale West during his contribution here this evening, because at no point in time my colleagues spoke about any constituency or any group of citizens or any geographic part of Trinidad and Tobago in any derogatory manner. And Madam Speaker, I want to tell Lavendale West that I listened to him very attentively. And whilst he may try to sidetrack me, I will possess the necessary mettle to underscore his narrow approach to this debate here today. Madam Speaker, because when he rose to pilot this particular legislation, he focused on the issue state. Yes. When the member rose to pilot this particular piece of legislation, he focused on the problem and indicated that it was something that was affecting his constituency, and this legislation would deal with not only in his constituency, but throughout Trinidad and Tobago, where the whole issue of trespassing was affecting all citizens, Madam Speaker. And if he cannot remember, and all of his colleagues who contributed to this debate and who may contribute at some point in time tonight, if they cannot remember, I want to remind them where the member for Lavendale West also focused on the issue of someone who had migrated to the United States of America, and when he returned, he found that his property was occupied by criminal elements and undesirable elements for a period, I think, of in excess of 3 months, Madam Speaker. And Madam Speaker, from his constituency? Yes, from the constituency of Lavendale West, Madam Speaker. And also, he indicated to this chamber this afternoon, and for the benefit of the national community, that there were approximately 11 reports for people who had to abandon their homes and their families were destabilized and so on as a result of 11, as I said, 11 incidents in East Port of Spain and at East Port of Spain, Madam Speaker. And in that context, I think that I have a responsibility to rise here and set the record straight in the context of this debate, Madam Speaker. You will have Lavendale West, you will have the opportunity to wind up during this debate, so you will have a second bite of the cherry, member. And at the end of the day, Madam Speaker, the Minister of National Security indicated during his debate that my colleague, the member for Approach East, did nothing to address the security issues that were confronting the partnership government and during his tenure as the Minister of Housing and Urban Development and so on, and even went to castigate the Prime Minister, Kamala Persad-Bissessar, for allowing chaos and so on to reign in the society, to just paraphrase his word. And that is in keeping with their mantra for the last 3.5 going into the 4th year, to continue to mask their incompetence and lack of delivery to the citizens of Trinidad and Tobago by blaming the former Prime Minister, blaming the former government, and not understanding their role and responsibility from a manifesto point of view and their successive budget presentations and so on, and the lack of implementation. I just want to remind this House that my colleague from Oropouche East did utilize the opportunity to use or hire private security firms and so on within the operations of HDC with a view to stamping out and reducing the presence of criminal elements and what was taking place in the respective HDC communities and so on within the operation of Trinidad and Tobago. So, Madam Speaker, I hope that the member for Laventille West, who has the responsibility of piloting this debate, piloting this particular piece of legislation, will respond to the concerns of the opposition in the context of our wider responsibility. At the end of the day, whilst you may say that this particular piece of legislation may not have to do or have no bearings on persons losing their homes and so on from the point of view of mortgage payments or their inability to deal with their mortgage payments, any responsible government and any government worth their salt will be concerned about when law-abiding citizens lose their homes and when families are destabilized in any form and fashion. And if you are not prepared to listen to that, then you must go down in history as the most incompetent government and the most uncaring government in the history of Trinidad and Tobago, Madam Speaker. So, Madam Speaker, with these few words, I want to say that the opposition will continue to fulfill its responsibilities and be an opposition that will continue to bring to the fore the shortcomings and the lack of what I would call compassion and caring on behalf of the citizens of this country based on the propaganda that is being peddled in this particular House here this evening by the members of the government. I thank you.
Member for Laventille West.
Thank you very much, Madam Speaker. Thank you very much, Madam Speaker. Madam Speaker, as I rise to wind up this debate, when I listened to my friend, the member for Couva South, I imagined him sucking a whole pile of sugar cane and getting an excess of energy, a sugar rush. The man went from 0 to about 150, just so, Madam Speaker. But, Madam Speaker, more importantly, I would usually speak extemporaneously from this floor and otherwise. It's true. But it is only fortuitous, and for which I thank God, that I decided on this occasion, since I was presenting this important measure, to write and to read my speech here today. I thank God for that. Because these twisters and turnabouters on the other side, they try to twist that which I said. You will recall, Madam Speaker, you're a twister, you could twist her socks.
48-4 and 48-6, Madam Speaker.
Please continue, Member for Laventille West.
Thank you very warmly, Madam Speaker. Well, just a metaphor. Some people twist shoes. They could twist a socks, nylon. Madam Speaker, I said in my presentation today, within the first 8 minutes or thereabout, and I quote, hence the main purpose of the bill is to plug this loophole in the law, as I mentioned, to modernize the penalties. This problem has been going on in our country for many years and is far more widespread than most people would imagine. From Caranage to Toko, from Chaguanas to Cedras, the criminals are distressing, often defenseless people. That's what I said. in the name of God? Why are they so? Fake News Congress. It was the member for Oropouche East who got up here, and the Hansard will bear reflection of this. And if I'm wrong, I'll walk proudly to the Privileges Committee. But it is the member for Oropouche East who got up here and said after me that what the government doesn't really want to say, he would say it. And he went on to tell us this is really about a certain community. The member for Oropouche East said that. And yet my friends, ignoble as they are on the other side, tries to put that on me. This is a national problem, and we don't make ad hominem law for no one group, we make it for all. With that said, might I proceed in true PLM and this government style to wind up this important measure and bring some clarity where darkness and dumb might have prevailed. The member for Oropouche East told us that this law will not work, it is a patch-up thing, and we should have completely repealed the entire Trespass Act. And so said the member for Caroni Central. I simply want to say to my friends that I heard the member for Caroni Central say in plain terms today that trespass, the offense of trespass, old as it might be, established in the law of 1852 as it was, is still very relevant today. All we have done today is twofold, if I might repeat myself. It is to create two new criminal offenses to meet certain social circumstances, from Caranage to Toko, from Chaguanas to Cedras. Two new offenses in 5A and 5B, and in addition to that, to modernize the sentences in the existing Trespass Act so that it would reflect today's reality. That's all we did. I give way to my friend.
I wanted you to explain 5B more for me, please. Because it says about unlawfully on a land or dwelling house, and then you come afterwards using force as the only reasonable method to get back a lawful possession. It's basically a dichotomy. And then you're fined. It just doesn't make any...
It appears as though you joined my friend and you had some extra sugar cane too. But take it easy. Take it easy. You're manifesting a sugar rush too. Take it easy. I'm coming to that. The government took a policy decision as being properly elected, we are entitled to do, that we should amend the Trespass Act as distinct from repealing and coming with something else. And we did that with one purpose, and that is to criminalize the brutality of people's constitutional rights. That's our decision. That's what we've done. And nothing more. Home invasion, I want to say for the benefit of all my friends on the other side. And before I do that, I want to remind my friends on the other side that it was the member for Mayaro speaking here today who gave us one example from his constituency in Mayaro.
That's right. He gave it. And it happened in Mayaro too.
And my friend from Moruga Tableland says he has had reports of that in his own constituency, Toko Sandy Grande, and I rather suspect all of us. But the deception that characterizes the conduct of some of our political opponents is always manifest. That is why we have to pray and give them Psalm 91 by the day. Madam Speaker, for the benefit of my friends, home invasion is quite a different thing. I am sure I heard the member for Port of Spain North St. Anne's West. I've heard the Attorney General here today explain the fundamental difference between home invasion and what we are dealing with called forcible entry and forcible detainer. Home invasion is where typically persons enter unlawfully, enter a home, and commit all manners of offenses therein, from wounding to larceny to rape to robbery, all manners of things. But the significant difference is in a home invasion, they demonstrate no intention to remain in occupation of the premises for the foreseeable future. That's the difference. With forcible entry and forcible detainer, it is completely different to home invasion.
Expel the lawful possessor.
Because the home invader does not intend to expel the lawful occupant of the premises or the home. He intends to commit a number of arrestable offenses and go about his business with his loot, leaving them in a state of devastation. That's the difference.
Explain them. They don't know.
They took objection to the use of the term servant. The member for Oropouche East said master servant. Well, there's no mention of master in here. It spoke to servant. And if they want to change the word servant to worker or employee, we have no difficulty with that because the meaning and the essence remains the same.
Synonymous.
But you see, when you are nitpicking, when you are looking for things, a peg to hang your hat on, that is the condition they found themselves in today. Good law. Living law, as my old tutor, Dr. Roger Cottrell from the University of London taught us. In his book, The Sociology of Law, he had a dichotomy between the law. Some was lawyer's law, and some was living law, which directly affected the lives of the people. This is living law, and it is so good and so useful and so timely. They could find nothing seriously about it, so they started to nitpick about servant and such matters. The member for Oropouche East, and I think other members on the other side, spoke in very derogatory terms that the Trespass Act, all as it is, speaks to putting up a notice on a board with a stick. Well, Madam Speaker, I want to let you know, as we speak today, in Canada, in Barbados, in Guyana, in Australia, everywhere there is land and you want to inform a trespasser that this land is owned and he ought not to trespass, it is done by putting up a notice in a conspicuous place. And as my friend for Port of Spain North, I think it was on the AG said, you can't send it by email, you can't send it by text or WhatsApp. The notice in the conspicuous place on the land is notice to the whole world. And as you know, when you're about to purchase land or occupy land, you have a duty as a buyer on the principle of caveat emptor to see and let the buyer beware. So if you were planning to purchase or planning to occupy illegally, the notice tells you somebody owned this. So let me move on from that. But again, Madam Speaker, that was an example of their vain thinness in trying to find fault with good law. The question of lawful possession, let me deal with that. And they gave the example of someone who might have entered premises as a tenant and stopped paying the rent at some point. Is such a person, they ask, a lawful or unlawful user? Might I let them know, according to ordinary and basic principles of landlord and tenant and other aspects of the law, if a person went into premises as a tenant and at some point stopped paying, that person is a defaulting tenant. That does not make them a trespasser. And as against the landlord, there are several remedies. Distress is one of them, where you could seize their goods for non-payment of rent. You could file a claim in the court for non-payment of rent. You could, a number of remedies. Ejectment proceedings, the old Section 94. I can't tell you what it is now. We've been out of the business for a little while, doing public business, Madam Speaker. So the defaulting tenant is not a trespasser. And there are various remedies on the part available to the landlord in those circumstances. And that is quite different from forcible entry, which is what we are creating in Section 5A today, and worse still, forcible detainer. Again, I must move on from that. Unlawful possession, just by way of further clarity, means or implies at the very least where possession is prescribed by law. So let me now respond to a matter that the member for Caroni Central would have raised. He questioned us as to whether the farmer who is on state lands, for an example, cultivating the land, whether he could be a victim of this. The answer to that is a plain and simple no. For one thing, there's no evidence on your hypothesis that he entered by force. And both these offenses require the element of entering or retaining or detaining the land by using force or threat or intimidation. It does not apply. Let me take a drink for that. Plain, clean, cool, unadulterated water.
Don't you give way?
No. You had your fill.
I just want to ask you a simple question.
You had your fill. Let me continue. So, Madam Speaker, it does not apply. And the question of lawful occupation, we've heard it said many times this evening, could be had on the basis of a license, it could be had on the basis of a lease, it could be had on the basis of a deed, it could be had on the basis of a certificate of comfort, which in the case of the certificate of comfort is a statement simply telling the occupier of the land that the state will not act against you and dispossess you.
Yes?
That is what the certificate of comfort essentially says.
Yes.
So this law really seeks to return or to give back actual possession to persons who had lawful possession, as I have defined it, as against persons who use force to enter into occupation or possession and to detain, to hold it. Now, there's a difference between occupation and possession, in a sense, but essentially it's based in authority. And as you know, planting land can be evidence of occupation even if you don't live there. Cleaning land is evidence of occupation even if you don't live there. And possession. And as the law says, just for the benefit of those outside of this chamber, and certainly my friends on the other side, who put a very pathetic response to these measures today, just for your benefit, if you are in occupation of private lands for 16 years unchallenged or undisturbed by the owner of those lands, the paper owner that is, then you can make a claim under the Real Property Ordinance, and you ask in that claim the court to insert your name on the records at the registrar's office as owner thereof, upon proof of certain things. And in the case of state lands, that 16 years climbs to 30 years. The member for Oropouche East, he made mention of other pieces of criminal law, the Larceny Act, the Firearms Act, and the Summary Courts Act, and he talked about rogues and vagabonds. All of those, as I said, in relation to home invasion, has to do with criminal offenses. A man has a firearm, but he goes into the premises, he does something, he comes back out. And as the member for Port of Spain North pointed out painfully today, is that these are separate and standalone offenses, and the police could deal with those quite apart from this. This has to do with forcible entry and forcible detainer. And we are here, as I have said repeatedly, but must say again, to protect the constitutionally enshrined rights of the people of Trinidad and Tobago, who, against the state, would have action in the Constitutional Court for taking their property, but would have none against criminals for two reasons, as I said earlier. Because one, only the state could infringe your constitutional rights, and two, No, I don't forget. You don't worry about that. So only the state could infringe your constitutional rights. I'll come to the other one shortly. I'll come to that. So mere entry, in the case of the Larceny Act, of which Section 26 is burglary, and of course, as Minister Young, the member for Port of Spain North, had to clarify to Caroni Central, the question of sacrilege, which yields 10 years under Section 26, I think it is, of the very Larceny Act. Those are not going to be affected by this. Squatters are not going to be affected by this because these two new offenses require evidence that you entered using force or threats and intimidation. And the other offense, 5B, where you stay in the property on the basis of such force, threats, or intimidation. So squatters, in the generality, are not affected by this. And as it relates to the Ballantyne case that he made passing reference to, which I must tell you I didn't immediately know about, but I just gathered from what he said, and I take it at its face value. He raised the question of two people, the honorable member. He raised the specter of two persons, neither of whom had title to the land, and they were fighting for possession. Well, in which case, both are subject to sanction by the paper owner. Both. Madam Speaker, state lands, Section 6 of the Interpretation Act tells us that the state may take advantage of the provisions of private law. All of the laws touching and concerning land, the state may take advantage of those provisions. And this bill, which is before us, makes that very and pellucidly clear. So whatever rights a private person would have had against another individual, the state can enjoy the benefits of those rights under Section 6 of the Interpretation Act. So that answers questions that my friend raised. And just for the purposes of another example, if the person went into unlawful possession of an HDC property, and by the way, HDC is a corporate entity, private and apart from the state. So if a person, yes, a statutory body, if a person went into occupation of an HDC property, the HDC has its own remedies as against that person. But if the person was an intruder and used force to go in and force to stay, then he or she would have committed the offenses as described herein in the new sections 5A and section 5B. I hope that I'm answering all of the little trifling issues that my friends conjured up today. Yes, you are. Yes, conjured up today as big, big, big reasons why they should find objection. Thank God this bill doesn't require a special majority. Otherwise, the people of this country will not have gotten the protection that this government has come to provide. Yes. Will not get it. Lecture them. Especially since I pointed out in my opening comments that they were fully aware of the problem. They promised to do something about it. They did nothing about it and coming to tell us we should repeal the whole thing today. Just keep quiet.
You sound professorial.
No.
And as for the question of anti-gang, I had made a note, but the member for Port of Spain North dealt adequately with that, and I need to say no more.
Laventille West, your 30 minutes have expired. I think leader of the House.
Thank you very much, Madam Speaker. In accordance with Standing Order 15.5, I beg to move this House to sit until the conclusion of the matter before it. Thank you very kindly.
Honorable members, the question is that The House continues to sit until the matters before it are concluded. All in favor say aye. Aye. Any against? The ayes have it. Member for Laventille West.
Thank you very much, Madam Speaker. Time has gone so quickly. I heard a member on the other side, Orupuchi, made a submission that he would like to see law that says stop police officers, imagine that, from becoming servants in public life like we are. Well, I was a police officer. And had I not been here, they would not have gotten the wonderful lecture that they are now getting in the business of land law. They would have remained in their ignorance. And the member for Toko Sani Grandi was a senior, I was just a constable, but she was a senior police officer, left the service proudly at the rank of assistant commissioner. So today we benefited, the House and the country benefited from a view of the law in front of us today through the eyes of a senior police officer with experience. And I want to congratulate her and thank her. On the other hand, with all of his warts, they had a former police officer called Jack Warner in their cabinet. He was a hero. Well, they could have done without him.
As Bo's Caroni Central's friend.
Madam Speaker, let me go very quickly. I said this is not going to affect squatters, and I dealt with the question of this repeal. Madam Speaker, I want to treat with a very important issue before I go. We indicated that trespass, the offense of trespass, is still relevant today. So the law as it now stands in Section 4 of the Trespass Act 1107 says, and I quote very quickly, any person found at any time in any lands on which or near which there is stuck up in some conspicuous place a notice in legible letters forbidding all persons to trespass, not having some reasonable cause or excuse for being in the place where he is found, or, in the absence of such notice, any person found in any lands who refuses to quit the same upon request by the owner of the lands or his servant, meaning employee, is liable on summary conviction, and previously, the law now is to a fine of $200. And we just amending that and saying to a fine of $50,000 or to 10 years imprisonment. England has criminalized that. And because the Trespass Act and squatting is still relevant today, this provision is just a simple amendment to increase the fine. And of course, I have dealt with that already. I don't business. Right? And of course, that compares with the new offense we are committing, we are writing in, which says, and I quote again, a person who uses force, there's 5A, threats or intimidation to enter land or dwelling house, which is in the lawful possession, and I dealt with lawful possession already, of another person, in order to expel that person and take possession of the land or dwelling house, and does so, and hear this, Madam Speaker, and does so otherwise than in pursuance of an order of a court or other lawful authority, commits an offense and is liable on summary conviction to a fine of $100,000 or imprisonment for 15 years. Madam Speaker, I want to bring your attention to the words, and does so otherwise than in pursuance of an order of the court or other lawful authority. In other words, if a person knows that he has lawful title to the land, he doesn't have to go and try to toss off the person to be possibly considered under 5A or 5B. He goes to court, he gets an order of the court, and then he shows up. Now that's the sequence. It matters not how long it takes. It matters not. This is his land. So he don't have to go and expose himself. We have the defense of self-help where you can escort somebody off your land, put them off using physical terms. But that is frowned upon by the court, as the Attorney General reminded us, and all lawyers will know. And therefore you get an order of the court, and all will be well. Thank you very much. Time is the master. Madam Speaker, so I think I have covered sufficiently, adequately, all of the very trifling issues that our friends have raised. And it falls to me now, as I conclude in my winding up, to remind the people of Trinidad and Tobago that this government, recognizing this serious lacune, as we call it, loophole in the law, a loophole that has allowed persons without the possibility of criminal sanction. You've heard from my friend Fotoko Sandy Grandi that even as a senior police officer, they felt helpless because they did not have, as the member for Port of Spain North St. Anne's West described it, they did not have the tool, the equipment to do the business. This government, recognizing that, not acting in any tardy manner or in lack of concern, or having preferred to let people off the hook with Section 38, 34. We want to bring people in the loop to protect the citizens and their constitutional rights. And that's the difference between this government and that one. As strenuously as we try to protect the rights and the constitutional rights and freedoms of the people of this country, it appears as though others before us were equally strenuous in doing that which was wrong and protecting wrongdoing. And Clause 34 is the high point of that. We had to come here Saturday, just very quickly as I close. We had to come here Saturday to repeal that.
Speaker 48-1.
Section 24. They made it into law. Section
24. Well, member for Laventille West, I'll ask you to move on, please.
I thank you, Madam Speaker, and with that, I beg to truthfully move.
Honourable members, the question is that a bill entitled An Act to Amend the Trespass Act, Chapter 1107, be now read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Trespass Act, Chapter 1107.
Minister in the Ministry of Attorney General and Legal Affairs.
Thank you very much, Madam Speaker. In my notes. Thank you very much, Madam Speaker. Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Trespass Amendment Bill 2019 be committed to the Committee of the Whole.
Honourable members, the question is that the Trespass Amendment Bill 2019 be committed to the Committee of the Whole. All in favor say aye. Any against?
Yes.
The ayes have it. The House will now go into the Committee of the Whole to consider the bill clause by clause. Honourable Minister and Whip, can we take clause 1 to 7?
Yes, Madam Speaker.
All right, sure. Okay, so we do them clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. The question is that clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill.
Madam Speaker, we propose an amendment, if you would permit us. We propose that in clause 4, in the definition of premises, the insertion of the words or any part thereof after the word structure in B, to take into account, Madam Speaker, any part thereof as the words themselves explain, as opposed to the structure on a whole. And therefore, we would like it to read, we propose that it now reads, any building or structure or part thereof, whether permanent or temporary, and whether fixed or capable of being moved.
Could you read that again, please?
It should now read,
Any building.
B, any building or structure or part thereof, whether permanent or temporary, and whether fixed or capable of being moved.
Okay. The question is that clause 4 be amended as follows. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Member for Kumutu Mansinala.
Chair, concerning the section 4, section 2 of the Act, B, where it reads in the definition of owner by deleting the words possession of any land and substituting the words lawful possession of any premises. I just want to ask, how does the minister intend to assist persons? How does this have impact upon persons who are currently awaiting either deeds or licenses or leases or certificates of comfort? That is the only way you can prove to any court of law, to any police, that you are in lawful possession of any premises. So in the absence of these certificates or deeds or licenses, how does this law, how will it impact upon persons who currently do not possess it?
Could the member explain further what you're talking about? As against who?
We have an acting commissioner of police right now with over 350 files. Commissioner of State Lands, sorry. Commissioner of State Lands with over 350 plus files on the desk that persons are awaiting leases or deeds or licenses or so forth. The Commissioner of State Lands, yes, my error, Commissioner of State Lands. And as such, we have persons currently are not in possession of any title to their premises or lands.
It would not be correct to say they don't have title. They may not have a deed or a lease, but that does not mean they don't have title. And are you wondering whether this will act against them?
Yes, I'm asking.
No, you are. These two new offenses speak specifically about force, using force to
absolutely,
take possession.
Member, Chair. This is how it will impact. I'm just using me as an example. I am on a piece of, I'm in a dwelling place. I do not have anything as yet. My file is in the Commissioner of State Lands, and someone comes and forcibly removes me from my premises And therefore, I go to the police for protection. The police is going to ask, show me ownership. But I don't have anything.
Madam Chair, yeah, if I may assist, it's important to read the amendment in the context of the Act. So when you go to Section 2 of the Act, we're amending the definition of owner, and this is what it reads now. Owner includes the tenant, occupier, or other person having lawful possession of any premises. Let me repeat that. Okay, so the clause is Clause 4. Clause 4 amends Section 2 of the Act. In the definition of owner, they're changing the words. They're deleting possession of any land, and they're putting lawful possession of any premises. So, Madam Chair, I'm assisting in the interpretation by saying, owner now means the law will now stand the tenant, the occupier, or any other person having lawful possession of any premises. Therefore, all of the variables are included there. Lawful does not mean in the context of an occupier. An occupier could never have a deed to the premises. The tenant doesn't have the title or deed to the premises either. So when you look to the law as it's cast, as revised now, as amended now, it is never going to be that one has to be a legal, deeded owner of property to have the benefit of this law. It takes care of persons in the temporary licensed or occupational positions as well. So I understand what the member's concern was, and it's taken care of when you read the law as amended.
Which is that if, as an occupier, without any title, without any documents, etc., the person is violated, a trespass takes place on the occupier's property. Does that occupier have any legal rights
Yes.
under the law in dealing with the criminal element?
Yes, and I'll answer.
How is that?
Sure, I'll answer that.
Yes.
It's by the interpretation of the definition of a dwelling house. So the dwelling house means any structure or any part of a structure, whether permanent or temporary, and whether fixed or capable of being moved, which is designated or adapted for use as a dwelling residence. That does not mean that it has to be on property that is titled. It could include squatting, and therefore any tenant, occupier, or owner of that structure deemed to be a dwelling house has the advantage of being the virtual complainant in the matters.
So a squatter, not necessarily a land tenant,
Yes.
right, also has the same rights under the law if violated.
Yes.
So somebody can come because I'm a squatter.
Yes.
And try to take away my land.
Correct.
Right.
No, somebody cannot come under forcible entry or forcible detainer to invade your home. The issue of somebody coming under their rights to challenge you for adverse possession, somebody coming with a competing right of claim for your land, that's a different matter, which is a civil law matter taken up in the civil courts. So under the criminal law, the person who alleges you forcibly entered or forcibly detained in the context of home invasion, that person in the criminal law has the locus standi to take this claim. The civil law, I need my title to land, I have a competing interest to you, that's a different matter.
Which I might just add on the basis of the principle enunciated in Hinds and the Queen can only be resolved in a court of superior record and not before the magistrate who will be dealing with this criminal offense.
Madam Speaker, just for the record, to amplify what my colleague has very correctly said, it's only the superior courts of record that could hear claims of equity. So in the inferior court, which is the magistracy where we're treating with this, we're only dealing with the criminal law aspects. So just to put on the record that my colleague is 100% correct in that position.
Okay, so the question is that clause 4 be amended as follows. That is to say, under the definition, premises includes at B, any building or structure or part thereof, whether permanent or temporary, and whether fixed or capable of being moved. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 4, as amended, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it.
Clause 5.
The question is that clause 5 stand part of the bill. Member for Kamuto Mansinilla.
Thank you, Chair. Honorable Minister, clause 5. I see that in B, you're deleting the words to imprisonment for 3 months and substituting the words to a fine of $50,000 and to imprisonment for 10 years. In your opening statement, you indicated that there were only 11 cases really reported, and there was, in fact, an under-reporting of this type of crime. How do you intend to increase the reporting by this fine, the increase of this fine?
I don't think the fine or the sentence has any bearing on the question of reporting. Those will have bearing on the actor, the criminal. But the question of impacting the person complaining, those are matters that, as the member for Port of Spain, North St. Anne's West would have explained, by making the police service more efficient, by providing all of the supporting instruments to quicken, as the AG pointed out, the criminal justice system, and all of those things will give the citizens the confidence, the witness protection, the justice protection program, the confidence that they could stand up and defend their rights to their home and not just run away. And in respect of the 11, I had given you statistics during my presentation on the Port of Spain division, which I gathered, because I was speaking in part as Member of Parliament for Laventille. But as we established, this is widespread and nationwide. We could always get the statistics for the entire country thereafter.
Well, the minister has indicated, therefore, that you will be providing witness protection for persons who would be willing to report?
Well, the question of witness protection is a matter for the Ministry of National Security. When the police get engaged in investigating a matter, it is they as technocrats who will decide what action they should take in relation to which witness or witnesses. The AG wants to comment.
Madam Chair, the Witness Protection Program is pursuant to the Justice Protection Act. The Justice Protection Act is invoked to provide witness protection on the recommendation of certain players, including the DPP in participation and the execution of a witness protection agreement. So it isn't that everybody is entitled to witness protection, and there are certain circumstances around it. What will be a motivating and driving force in this kind of law is the Evidence Act and the accessibility of anonymous witness evidence and sequestration procedures, special procedures. So this is intended to treat with the fact that our law at present has no known offense of home invasion, if I put it in a simple way. This creates this matrix for this offense. It would not have qualified as larceny, as an offense against the person, as harassment per se. This is the fundamental right rooted to the Constitution, Section 4A, of depriving someone of their property. And therefore, this is a very unique position. Statistically, I can tell you there are thousands of cases. I've referred to them in the preliminary inquiries debate, where I gave the statistics for the number of preliminary inquiries, including offenses against the person and trespass and other factors. So it is not correct to say that there are only 11 matters. But in any event, right now there are 0 matters of this kind because this law does not exist.
Honorable Attorney General, this really, the law is being brought about to close the gap, according to the minister's piloting of the bill, indicated that it was ready to close the gap. How do you see this closing the gap?
Well, first of all, the gap is that there is no known law to treat with home invasion, and that is where you enter forcefully and you actually take possession of someone else's property with the intention to put them out. That's not just a mere trespass. That is evidenced by the extent of the fine. If you look to 5 capital A, where we put on summary conviction a fine of $100,000 and imprisonment for 15 years. So this is something to treat with the creation of an offense of the first of its kind in our books, and this is to deal with a problem which has in fact manifested itself, as has been reported in our newspapers in the recent years, in particular, starting with the period 2011.
I don't think it answers my question, Chair, because at the end of the
Well,
day,
you asked how it
I know.
closes the gap.
It doesn't close the gap as far as I'm aware, because you have persons who will be required to come in. You will have persons who will be required to come in to make this report, and their lives are going to be in danger. The reason why they did not come is because their lives are going to be endangered, and that was, I thought, was closing the gap, and I don't see it. Thank you.
Member for Port of Spain North, St. Anne's West, you wanted to make a contribution?
Yes.
Ma'am, the only thing I'd add to what the Attorney General said, I was going to point out there's a specific piece of legislation that governs the Witness Protection Program, is despite the best efforts of certain people to discredit it, there has never been a loss of anyone within the Witness Protection Program, and that is something that they should be commended for. And the program itself is only as successful as the confidentiality surrounding the program and the safe houses provided.
The question is that clause 5 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill.
Madam Chair, we propose a minor amendment to section 4, where we want to, clause 6, sorry, where we propose to change the word servant in lines 6 and lines 8. We propose to change the use of the word servant to the word worker, in keeping with existing law, i.e. the Industrial Relations Act of Trinidad and Tobago.
Do you have?
And therefore, Madam Speaker, we propose that it should now read, any person found at any time in any lands on which or near to which there is stuck up in some conspicuous place a notice in legible letters forbidding all persons to trespass, not having some reasonable cause or excuse for being in the place where he is found, or, in the absence of such notice, any person found in any lands who refuses to quit the same upon request by the owner of the lands or his worker is liable on summary conviction to a fine, and we propose, of $50,000 and to imprisonment for 10 years. However, every laborer or other worker in line 8 having or occupying any house or cottage or any room in any house or cottage on any lands, and the members of his family actually residing there with him shall not be liable to any punishment under this act by reason of his or their passing along, or upon any road, path, or way leading from any public high road to such house or cottage.
One minute. I think the difficulty we have is that it has not been circulated. So may I ask if it would be better that you delete the clause, the section, and replace it entirely?
No. Madam Chair, it's actually quite simple. The amendment that we propose to clause 6 would be very simple. If you look at clause 6, Madam Chair, after the word amended, we'll insert a dash, and we create a Roman 1 and a Roman 2. What is there, the words by to years, will be Roman 1. So section 4 is amended, dash, insert Roman 1, and then the wording by straight down to years forms the Roman 1. And then the Roman 2 will simply be by deleting the word servant and replacing with worker. Yes, it can. So, Madam Chair, the technocrats are saying that we would just put the deletion of servant first and then the other one second. So we would go, Section 4 is amended dash Roman 1 by deleting the words servant, which will be in quotations, and substituting the words, even though it's in plural, worker. That's in inverted commas. And then the rest of that wording that appears there would become Roman 2.
All right. So it's not the words. It'll be deleting the word
Yep.
servant and replacing it with the word worker.
Yeah, yeah.
Okay? All right, so that so let me put the question for the amended clause, and then we have the discussion. Okay? So the question is that clause 6 be amended as follows. 1, by deleting the word servant and replacing it with the word worker, wherever it occurs in that section. And 2, by deleting the words to a fine of $200 and substituting the words to a fine of $50,000 and to imprisonment for 10 years. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Whip.
Madam Chair, just for clarity, how many changes, Minister, that we had the word from servant to worker?
In this
How many,
amendment?
please? Yeah.
2.
2. I don't have the act in front.
2.
Make a suggestion, please, just for completeness. In clause 6, it should really read, for the purpose of the record, section 4 is amended, 1, by deleting the words or word servant, and we said wherever it occurs, and substituting the word worker. And 2, by deleting the words
After conviction to
yes. Yeah. Just for completeness.
Yes. That's good.
Yes? Yeah. Just to put it.
Do I have to put it again so that we all on the same page?
I just think, just for the record, so that it reads accurately, but I don't think we have to put it again.
As put it was correct. It was just reconfirmed.
The question is that clause 6, as amended, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it.
Clause 7.
The question is that clause 7 stand part of the bill. Carney Central? Okay. The question is that clause 7 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that clause 8 stand part of the bill.
Ma'am, please, no, I'm not deleting. Ma'am, sorry.
Member for Port of Spain, North St. Anne's West.
As I'd like to suggest to the Minister piloting the bill, and as I told my friend from Carney Central during my contribution, to cover the issues that he raised in his contribution, I'd like to suggest the addition of the word premises at 5A We're not deleting anything. So where we say intimidation to enter land or premises or a dwelling house. So we add the words after land, or we add the words premises or. Or you could say yes, correct. Or as the AG has said, land, comma, premises, and then it flows or dwelling house. Yeah.
Madam
No?
Chair, we just will circulate it with the amendment here, Minister.
Well,
But,
thank you, Member, for carrying East, because I'm now wondering whether what we're now being told is consistent with the amendment
Yes,
as circulated.
I want to draw this to your attention. What was circulated, Minister Young, is what you're saying is different from what has been circulated. Yeah, so you need to clarify it.
Madam Speaker, we propose to delete the words land or dwelling house or a dwelling house and replace that with the word premises.
And are we also deleted land or the dwelling house?
Yes, Madam
Chair. So an amendment has been circulated. An amendment has been circulated. Is what being proposed now consistent with what has been circulated?
Yes.
Member for Caroni Central.
I would like to engage the member for Diego Martin Northeast, and I feel that. So no, Laventille West. Sorry, I just looked. No, I just looked.
I'm better looking.
Come on, all you be able yourself. If you would agree not to delete anything and simply add the word or premises.
No, yes. Premises, although land is not defined, it will be given its ordinary meaning, but dwelling house and premises are being defined and added to the Act. Premises would include lands and dwelling house. As a result, your submission is not necessary.
So where you have the
page 3 of the bill.
Yeah. Madam Chair, if we ask the member to look at page 3 to the definition of premises, I'll read it out if I may. Premises includes any lands, any building or structure, whether permanent or temporary, whether fixed or capable of being moved, a dwelling house, etc. So there's a very comprehensive definition. I think it captures the point that you've raised.
Okay, fine. Okay.
Member for Baratar Samuel, you wanted to raise something?
Yes, on 5B. If you read it slowly, how could somebody be unlawfully in possession of a premises, and therefore using force as the only reasonable or practical method of recovering a lawful possession? It doesn't make sense to me, if you could explain it. You're unlawfully in possession of a house, and then you come, and the third or fourth line said, you are using force in a manner that would render the use of force as the only reasonable and or practical method of recovering lawful possession. You are committing an offense.
Well, in which case, since one person is holding on to it by force,
Unlawfully.
What this says here is, let me just go it over slowly.
Go it over slowly.
Any person who, being unlawfully in or upon any land, any premises, maintains or attempts to maintain his possession or occupation thereof, and does so by force,
Go ahead.
or in a manner that would render the use of force to displace him.
No, as the only
No,
reason
to displace him.
Where it says that?
That's it.
No,
As
it doesn't say
the
that.
only reasonable or practicable means of recovering lawful possession of the land, of the premises.
That's what it says.
So you're saying that you can use reasonable force to
Yes. Thank you very much.
Okay? The question is that clause 8 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 8 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 9.
The question is that clause 9 stand part of the bill. Member for Kamuta Mansinilo.
Thank you, Chair. Could the Minister indicate in clause 9A, what is the basis for the Minister being in this clause, and for why does it have to have such a impact in terms of bringing a subject to negative resolution of Parliament, and what necessary and regulation that you may feel may need to be done or brought to expediently. What is the reason behind putting this clause in 9A? What is your reasoning for putting this in this act?
What kind of right?
Madam Chair, because there may be need prescriptively to lend some assistance to this, it's reasonably contemplated that we could, if needed, improve the law by the use of subsidiary legislation. So in the event of any ambiguity or in the event of a recommendation that the parent law ought to include something, the usual mechanism that we use in legislative drafting is to provide for this type of position for regulations to be made. So it would allow for a smoother operation, let us say by the introduction of regulations which prescribe forms or a particular procedure, the manner in which you ought to approach the court, all of those things, the notices, the period of notice, all of these things can be done by way of subsidiary legislation, which is a less cumbersome process than a full debate in Parliament.
I understand what you're saying, but it also impacts upon 2 of 9. I believe that currently Central had raised concerns with it.
I just raised the question of why you're putting the... Sorry, Madam Chair. I'd raised the question of, I wasn't clear on it. Regulations made under this section may provide...
So Section 63 of the Interpretation Act provides that where a law does not say what the breach of the regulation penalty is, it's just $500. So this is to allow for a penalty higher than $500 to be applied, and it's something which we have done consistently in most laws, because what really ought to happen is we ought to amend the Interpretation Act to move that unduly low sum of $500.
Madam Chair, I would like to propose a minor amendment, or 2 rather, to 9A1. And I would like to remove, in clause 9, and I would like to remove the word "the" in line 1. In 9, well, yes, the second use of the word "the." Yeah?
So the minister may subject to negative resolution?
Yes, I would like to delete the word "the," and in line 2, I propose to delete the word "such."
Yeah.
In line 3.
Make regulations.
Correct.
Yes?
Yes, indeed.
All right, member for Caroni East.
Colleagues, I was just looking at the question of negative resolution in the context of 9A2, where there is imprisonment issue, and the fine is $25,000. But where imprisonment issue for 5 years is concerned, do you not think that it might be more appropriate to, I know you always find difficulty in saying affirmative resolution, but can we get your thoughts on that? If we ask for affirmative resolution, since it impacts upon an imprisonment issue.
Sure. Madam Chair, the type of regulations envisaged here mirror this approach of negative resolution mirrors the very procedures that we have for the judicial rules, so the civil proceedings rules, the criminal proceedings rules, which attract by far more attention and sanction. They are also done by way of negative resolution. So for consistency's sake, we have proposed that this happen. I just want to remind that the statement of 25,000 is a statement of maximum law. It's a maximum extent. It means that any amount below that can be applied. Similarly, the statement for 5 years, it isn't that it's a mandatory 5 years. Any amount below that could be applied as well.
Well, I think you have answered it in a case of where you said there are other pieces of legislation which carry the penalties.
And very importantly, negative resolutions stand for 42 days, not just calendar days, so there's an adequate opportunity. It's published by legal notice and laid on the Parliament's
for
floor.
us to debate.
Yeah.
But sometimes, you know, it slips us.
Of course, I do appreciate that.
Okay, so the question is that Clause 9 be amended as follows. In Clause 9A1, the minister may, subject to negative resolution of Parliament, make regulations as may be necessary or expedient for the purpose of carrying out or giving effect to this act. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
I would like to propose, in light of our agreement with the comments of my colleagues of this Parliament, that we should change the word servant to worker. That word appears in sections 6, 7, and 8.
All right. So just before we go there, we in Clause 9.
Yes.
And I've just put that the amendment, that the proposed amendment be accepted. I now have to put that the amendment now stand part of the bill. The question is that Clause 9, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Member for Laventille West.
Thank you very much, Madam Chair. As I was indicating, and for the reasons that I have stated, since we accepted that we should change the word wherever it appears, servant to worker, I propose a new Clause 10, Madam Chair, which should read in sections 6, 7, and 8, delete the words or word servant wherever it appears or occurs, and substitute the word worker. Yeah, where it appears again, yes. So a new Clause 10 will deal with that.
All right, so you have it? All right, so the clerk will read the new clause.
New Clause 10. In 6 and 7, delete the word servant wherever it occurs and substitute the word worker. 6, 7, and 8.
Okay, the question is that new clause 10 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The clause will now be read a second time.
Clause 10 in sections 6, 7, and 8. Delete the word servant wherever it occurs and substitute the word worker.
The question is that new clause 10 be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 10 now stands part of the bill. Honorable members, the question is that the bill as amended has now been reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This committee is now adjourned. The House will resume. Minister in the Ministry of Attorney General and Legal Affairs.
Thank you very much, Madam Speaker. Madam Speaker, I wish to report that the Trespass Amendment Bill 2019 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Trespass Amendment Bill 2019. All in favour say aye. Aye. Any against? The ayes have it. Minister in the Ministry of Attorney General and Legal Affairs.
Thank you very much again, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Trespass Act, Chapter 1107, be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Trespass Act, Chapter 1107, be forthwith read a third time and passed. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Trespass Act, Chapter 1107.
Leader of the House.
Very kindly, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 15th day of February 2019 at 1:30 p.m. Madam Speaker, at that time we will do Bill number 4 on the order paper, which is an Act to Amend the Magistrates Protection Act 2018, Chapter 603. Thank you very kindly.
Honourable members, the question is that this House do now adjourn. All in favour say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, February 15, 2019 at 1:30 p.m.